12/11/25 in bail application 3540/25. Para having regard to the nature of the allegation and the period of nearly a month spent by the petitioner in detention, the prayer for bail is allowed. Rest same as 6-7. It first thing to just party deal in view of the মজিটো দিলো সেইখিনি লিখি দি বুজি পাবাই
Agnes Miller.
May I please, your lord. Application for 483 of BNSS for granting regular bail to the petitioner, my lord. Lordship, Khitri Police Case number 92/2025, my lordship. Lordship, may I read the FIR, my lordship? FIR page number 17, my lordship.
yes read
সম্মানপূর্বক বিনীত নিবেদন এই যে মই ইংৰাজী 10/10/25 তাৰিখে সন্ধিয়া 6:45 বজাত এজাহাৰকাৰী মই আৰু মোৰ পত্নী ৰংমল্লী চৰকাৰে উভয় মালয়বাৰী নিবাসী মোহন দেৱনাথৰ ঘৰত কীৰ্তন নাম প্ৰসংগ কৰিবলৈ যাওঁ। উক্ত সময়ত আমাৰ দুই কন্যা ক্ৰমে अस्मिता सरकार 16 বছৰ আৰু হেমলতা সরকার 9 বছর ঘৰতে এৰি থৈ যাওঁ। উক্ত নিশায় প্ৰায় 9 মান বজাত মোৰ ভতিজা শুভজিৎ চৰকাৰে নাম্বাৰৰ পৰা মোক দূৰভাষী যোগে জনায় যে মোৰ কন্যা अस्मिता চৰকাৰে ঘৰৰ ভিতৰত বিচনাত অচেতন অৱস্থাত দেখা পাওঁ। তৎকালীনভাৱে প্ৰায় 9:15 মান বজাত মই ঘৰত উপস্থিত হৈ মোৰ কন্যা अस्मिता চৰকাৰক স্থানীয় ৰাইজৰ সহযোগত সোণাপুৰ জিলা চিকিৎসালয়ত ভৰ্তি কৰি যদিও চিকিৎসকে কৃতপক্ষে মোৰ উক্ত কন্যাক মৃত ঘোষণা কৰে। পৰৱৰ্তী সময়ত জানিব পাৰোঁ যে প্ৰত্যক্ষকাৰী মোৰ মামাৰে ভণ্টি ৰিজুমণি দাস আৰু ভাইটি গুৰুচৰণ দাসৰ ওপৰত উল্লেখিত পদকীয়াক্ৰমে সন্ধিয়া 7:40 মান বজাত মোৰ ঘৰত প্ৰৱেশ কৰে। উক্ত সময়ছোৱাত হেমলতা চৰকাৰে ভাইটি ৰিজুমণি দাস গুৰুচৰণ দাসৰ ঘৰত আছিলে। মোৰ উক্ত কন্যাৰ ডিংগিত আচাৰ গুৰুতৰ জখম প্ৰত্যক্ষ কৰক। উল্লেখিত পদকীয়াজনে মোৰ উক্ত কন্যাক
so your bail was rejected earlier
Yes,
Lordship is not rejected by the Lordship, not from this honorable
I
court.
know.
Lordship.
it's a case of murder.
but after perusing the CD it was rejected so
Yes.
we have to see the CD
Lordship,
Along with the postmortem.
along with Lordship postmortem and FSL report, my lord,
yes postmortem and FSL report.
will reveal the whole truth, my lord.
give it date
Lordship may kindly seek for the short date, my lordship. Petitioner in jail for not 37 days. It depends, my lord.
It is on 10th of December.
May I pray for a date? Humble prayer, my lordship. These students, my lordship. And on the basis of surmise and premises, my lordship, and FSL and postmortem report will reveal the lordship whole truth.
all right 8
Something. Obliged.
Yeah, please. Lord 483, petition lordship, petitioner is custody since 14/11/2025, Lord. And in this time, I only share my lord order for a hearing.
3rd of December.
Obliged, Lord.
Yes, but 180 of cadet lordship. Kindly, can I pay for audit? These are
short dates are over
27. Lord.
On 12th. On 10th.
what
8.
how many days
Lordship is a teacher of a high school. Of the false audit.
and 8 all right
Okay.
8
8th.
আইছে নেকি On the prayer of Mr. Provincial Learned Council petition, there is this as withdrawn.
Worship, kindly pass up the matter for the time, we take instruction. Seven also, Lordship, same prayer after some. Lordship,
My pleasure. Last worship, court was called for from the officer in charge of Bodorpur.
Lordship, to that regard, we have instruction. I would like to inform you that I have checked all the available case records, but no any case registered.
No case. Learned additional PP on instructions received submits that no case has been registered against the present petitioners. Sahabuddin Tapadar and Ziaur Rahman Tapadar at Bodorpur.
That
Police
report
station.
may be kept.
Report submitted by the IO be kept on the record in view of the petition stands closed.
Keep your
May I please skip? Letter may be one today. Because he has actually come off
At one, after we rise.
today itself.
No, he wanted at 1 o'clock. So at 1 o'clock, we'll rise, we'll fix it at 1.
After
Appear.
some time it's okay. Because CD has come actually, but come in the courtroom. He's already there in the and there some time.
No need to get so nervous. Calm yourself. Yes, you want it after some time.
After
Alright.
let us come to the office.
What was called for from Ragapur, the non-affair case.
That report is not whether any some other day. Lord. Honored.
Report not received as submitted by learned PP. List again on
Let it be on Friday, Lord. 21.
Publish. Worship, item 5. To report kindly allegation of
if injury report is available, it will be there in the CD anyway. Injury.
may appeal. Not for it for application, your lordship. Well. FIR page number 11, your lordship, annexure A. But then FIR has of
Who are you?
time the GPC.
Hmm?
Now concert,
Name.
your lordship, Abu Soid. Another one, Hemanto had. প্রধানমন্ত্রী গ্রামীণ order date 13/11/5 annexure F.
Right, annexure is F is 30, same order. Same date. 12/12.
Deeply approved. Intent.
Same order, if it interim is there,
Your lord.
it will be there.
I'm sorry, my lord, not be on time, but regarding item number 3, before I start with it, whether it's a case that under section 76 earlier now. Now, only thing is that on a
What do you expect from us?
no, that's what I'm saying, my lord, before opening the case, if your lordship will let. Because it's a purely a constitutional factual case, my lord. That is what I'm saying. She is the aged about 25 years, my lord. 24 years, my lord. And we could. That's why I pointed out, my lord. I'd like to draw your lordship attention to page 16, the type version of the FIR, my lord. Highly improbable story has been. He was a contractual employee under the Namuligo River with a promise to marry. They look for take a look at that.
When was he arrested?
On 7th. The lordship will turn to page 27 while reminding me, my lord, the court after perusing of the case diary and the report submitted, my lord, your lordship will see that during the course of the investigation, collected case from Doyang Guest House located in Arnold Township. Upon exam of case, it was observed that the accused and the complainant together multiple occasion entering and exiting the same room. We also seen arriving in and living together in the vehicle. belonging to the accused. So that's a wrong finding. So it can be this day if it is inside matter. Then again, 2 miler. A statement recorded from several witnesses of Doyang Guest House confirmed that the accused and complainant used to sit frequently at the guest house for lunch and would often spend time together inside the room. Then has jointly occupied room numbers such as the hotel staff stated that both the individual in each other as husband and wife.
The paragraph 4, IO himself says they were in a romantic and physical
Yes,
relationship.
that
Yes,
is what
PP.
the main. The contents of each are clearly indicate accused and the complainant are romantic and that's why my I thought
That he is married and all that, those are their personal matters, but P76 cannot be a serious matter, it can't be invoked. All right, we'll call for the CDO interim, we'll release it. Heard Mr. Jet Ramal and counsel for the petition. Additional decision application. It appears from the FIR that the petitioner, who is an employee of NRL, Mumuligor, was in a relationship with the informant and as per the allegation, the petitioner established physical relationship with the informant upon promise of marriage. In course of such relationship, they had also started living together at different places, including NRL, guest house, and private hotels. To stop call for the CD, having regard to the nature of the allegations and the observation of the IO himself that the accused
Actually, observation has been reflected in the order dated 8/11 Annexure 3.
as reflected in the order dated
8/11/2025.
11/23 passed in the GR case 591 of 2025, that the accused and the complainant were in a romantic and physical relation, provided it is directed that the petitioner shall be released on interim bail of rupees 50,000 with one surety for like amount satisfaction of the
Landed CM,
Come-
Golaghat matter.
in connection with the further provided that the petitioner will cooperate with the investigation and shall not try to influence or intimidate the witnesses in any manner. List on
18 December,
18, 20, 11, 12.
March of it.
Please, Your Lordship. Anticipatory bail application. Lordship has dealt with that matter, my lord. Techno Global Unit. Is that 24th bail application? All 23 are on. I have annexed some of the orders, my lord, from page 50.
who are you?
My lord, Ariful Islam and Ashikul Islam, these, my lord, the person who was the representative, these, where his age here, my lord. The candidates had approved the university through these.
Okay, is 30, huh? Same order. 14/11/25. Same date. 28/11, I think.
I'm deeply obliged.
Please, Lordship. Lordship, therefore, bail application, Lordship. Allegation. Lordship. The allegation raised in the FIR, Lordship, previous hurt and attempt murder, Lordship. Now, that is true, Lordship. This peasant petitioner is in present place of occurrence, Lordship. The FIR is page 19, Lordship, the vernacular in Assamese, Lordship. May I read, Lordship? শ্ৰদ্ধা সহকাৰে আপোনাক জনাওঁ যে 9 তাৰিখে পুৱা 24মান বজাত আমি কয় দিয়ে তেওঁৰ এই চিকাৰী নম্বৰ আমি মিৰিগাঁও তিনিআলি হৈ কামলৈ ওলাই গৈছিলোঁ। সেই সময়ত লোকনাথ আৰু তেওঁ সন্তোষজন ব্যক্তিয়ে তেওঁ গাড়ীখন ৰখাই গাড়ীখন ক্ষতি কৰিছিল আৰু তেওঁ মৃত্যুৰ উদ্দেশ্যে আৰু মিড্ডা বাঁহৰ লাঠি তৰোৱাল লৈ নিৰ্মমভাৱে প্ৰহাৰ কৰিছিল। That's allegation. Now, Lordship, present petition, Lordship. I have annexed, Lordship. The age is about 70 years. 11, Lordship. And now, Lordship, this present petitioner is the President, Lordship, the Bihottor Kolkata Anstik Jeshtha Nagarik Unnayan Samiti, Lord. And Lordship, this present petitioner is suffering from a various health condition. And I have annexed all medical documents, Lordship. Page 21, Lordship, medical document, Lordship. The history, Dragonis, the case of the with fever, the present with complaining on pain operating chest. Now, the page 20 medical, page 20 photograph of medical, and lordship, page 20 X-ray lordship. Yeah, it's a photograph. I am lordship. Kindly, the leniency of the lordship.
What is your defense?
Defense is lordship. One is the senior citizen lordship, and another
No,
is
that is
this
not a
medical-
defense. Being a senior citizen doesn't entitle you to attempt to
That is-
murder.
that is correct, lordship. But as per FIR, they raise in allegation, lordship.
You have not
But I am
stated
present.
anything. You have not stated anything in your petition regarding your defense.
No, lordship. And health, medical is at least lordship. Medical issues may be considered lordship. Is suffering from the chest pain, lordship, and now 7 years.
Yes, yes. We have very good facilities in jail now. With regular visits to
At least
hospital.
lordship.
And from the
Okay.
medical documents, you have annexed.
Yes, 21 lordship.
Yes.
21.
What is that?
History of
Yes. What are we supposed to understand from this?
There is lots. I have is suffering from the various medical documents I have not annexed, my lord, the year 2020, 24 and 5 lords. This is latest report, my lord, 2410 lords.
But
Yes.
you are fit enough to attack that person.
No. It is absolute false.
No,
lords.
well,
That
then
is-
why
that
were
is-
you
that is-
why were you
that is
implicated? Have you
present.
set up a story?
No, that is present. That is correct. The
What?
70 years, the senior citizen, and now she is reputed in
Along with the injury report.
First, learn to draft a proper bail petition giving a defense and then pray for interim. Yes, next.
Lord. It is-
Second,
Wait, this your lordship. If this is a second time anticipatory bail applicable as the up-to-date case study.
on 5th,
Oblige.
Please, your lordship. This is the pre-arrest bail application, lordship. Applications are under section 3184 and 5 of the NA. Lordship will find the FIR on page 9, lordship. May I read, lordship?
Who are you?
I am lordship Ranjan Bora, lordship, and he is a landlord of the main accused, who is Mriganko Kolita, lordship. Now, lordship, how the person who took the vehicle on lease, how he came into contact with the complainant, there is the present petitioner role. Lordship, as a tenant, the main accused, and the complainant who was about who wants a person for leasing his own vehicle, the present petitioner came into the scene, and then as he know his own tenant and the complainant, he introduced both of them to themselves, and they executed an agreement, lordship. And lordship will find that agreement on page 21 and page 22, lordship. Page 22 is the handwritten one. Page 21 is the translated one, lordship. Here, the present petitioner is neither a witness to the agreement, neither here the owner of the vehicle has been mentioned, and the one who took the vehicle into lease has been mentioned. Now, if we come to the other part of the present FIR, lordship, here it is in the FIR, it is categorically stated that there are several cases pending against this person, but that is not true. Only the fact that is there is another case has been registered against this Mriganko Kolita, who also happens to be the tenant of the present petitioner. Now, in the FIR itself, in the present case, it is stated that when he
when the house of the Mriganko Kolita, who is the prime accused, took the vehicle. He was not available as he is in jail And now, Lordship, he is in jail. That is a fact, and he is in jail for he is in judicial custody in a Dergaon case 106, and he is still in judicial custody.
Who, Mriganko?
Mriganko, he is still in judicial custody. I have mentioned that FIR also, and there in the FIR itself, his name is reflected on page 19. My role is only that I have introduced both this person so that they can take the vehicle. And this dispute might not also last longer once the Mriganko Kolita comes out of judicial custody. He might be able to pay something, or he might be able to return the vehicle.
Some time ago, we had a similar case.
Lordship.
Which place is this?
From
This is
Morioni.
from Lordship, Morioni, Lordship. Jorhat, Lordship. The other case is from Dergaon, it will be from Golaghat, Lordship. In which the Mriganko Kolita, one who took the vehicle, is in judicial custody. There is no other case against the present petition. It is a false statement in the FIR. Only there is a grudge that I have introduced this person to the complainant. Only because of that, this my name is there. And it is true. I'm admitting that. I have introduced both this person. Out of good faith, without knowing the consequences. Ready to record my statement.
Alternate counsel for the petitioner. Petitioner. An application. Paragraph 3, okay. Thanks. Call for the CD. It is submitted that the only role of the present petitioner is that he introduced the informant to the other accused, Mriganko Kolita, as he knew the persons concerned, and that the informant was your tenant,
My tenant,
his tenant.
not the informant, Mriganko Kolita.
As the said, Mriganko Kolita was his tenant. So how do you know this fellow?
This complainant,
Present informant?
informant, I know him from a long time.
And the informant is also known to him to the petitioner for a long time. Having regard to the above provided in the interim that 50,000 once year interim pre-arrest action. Further provided that the prisoner shall appear before the IO within a period of 7 days from today. He shall not try to intimidate or influence the witnesses in any manner. Just again on
16.
Deeply obliged.
yes, yes, yes.
First,
The prayer of learned petitioner
I'm for the respondent number.
Place the matter again on. Even
It's Rahul. Pass over for time.
how many time beings have piled up?
Let him come, my lord. I am for the petitioner, my lord.
Oh, you are for the petitioner.
My lord.
All right, we can start then.
Yes, my
Which one?
petitioner, my lord, is before your lordship, my lord, against the 20% compensation in the NI case. The facts of the case, my lord, right after receiving the NI demand notice, my lord, petitioner had replied by filing a reply to the demand notice and stating that this is not my account, this is not my check. The lordship will find that reply, my lord, at page, my lord, 27, my lord, 28, my lord, Annexure 3, my lord. Relevant paragraph, my lord, your lordship will find it. There are 3, my lord.
Age?
Page 28, my lord. Your lordship had taken up 394, my lord.
You are the accused.
I am the accused in the NI case.
Yes.
I had replied that this is not my account and this is not my check.
Hmm.
I had already replied and let him know that this is not my account and this is not my. And I had already also filed a FIR before the Hatigao police station in this regard that he has manipulated my signature in a check. And in that, my lord, FIR, my lord, the complainant is, my lord, out on bail. Now, after appearing in the NI case, my lord, I have stated the facts before the Thane trial court, my lord. And I have also pointed out the demand reply to the demand notice, my lord, which is also part of the, my lord, complaint petition, my lord, that I had stated that this is not my account, my lord. But even after that, my lord, they had filed a petition under 143A and the Thane trial court had directed me to pay 20% of the check amount, my lord, amounting to, my lord, check amount is, my lord, 16 lakh. My lord. I am directed to pay, my lord, 20% of that amount. My lord. And my lord, during the continuation of the trial, my lord, the learned.
Do you have any document from the bank?
Yes, my lord.
as
The
to
bank
whose
manager
name?
has also already, my lord, appeared before the trial court and he has deposed that this account does not belong to me, my lord. The trial court record is already before your lordship. So for your convenience, my lord, this is, my lord, the deposition of the bank manager, my lord, of South India Bank. The second page you will find, your lordship will find at para 11, my lord. The account number is not related to accused Madhuram Deka, my lord. Exhibit P10, that is a check, belongs to Bhaspati Das, care of Mrs. B.N. Pathak, my lord. The said account is presently at dormant. I am, my lord, Madhuram Deka, my lord. This account belongs to one, my lord, Bhaspati Das.
Where is the check?
Check your lordship will find it page number 22, my lord. I have also, my lord, contested the, my lord, signature, my lord. This is not my signature. I have already stated that I am willing to go for forensic examination, my lord, if this is my signature, my lord. Now, my lord, as per my lord, section
It
one
is
thirty-eight
not,
of
is
the,
not the name of the person printed on the check nowadays.
my lord, this is some, he has manipulated my.
Hmm?
My lord, because when a person writes a signature, my lord, the fluency is not there, my lord.
No, no,
Clearly visible.
we need that. In our checks, the names are also printed.
Yes, my lord. In this check, names are not printed, my. In this regard also, he has stated, my lord, the bank manager, my lord,
Yes,
at para 15, my lord.
there is something underneath the signature that is not legible.
My lord, no name is there in the check.
Yes, what were you submitting?
My lord, in this regard, my lord, why name is not there, my lord? The bank manager has stated that, sometimes instant checkbooks are issued to account holder, my lord. In that case, my lord, names in the checks are not there, my lord. Now, I am submitting, my lord, as per my lord, section 138 of the NI Act. My lord, for institution of a case, my lord, under 138, my lord, what is your lordship will find, my lord, where is check drawn by a person on an account maintained by him, but in this case, my lord, this account is not mine, my lord. So since the account is not mine, my lord, how I am, my lord, 138 proceedings can be drawn against me. My lord, I would like to place a judgment of the Supreme Court, my lord. This case, my lord,
This must be available in the
yes,
case
my lord.
record.
Already, my lord. In this case, my lord, the lordship will find it from para 22, my lord. As already noted herein before, in para 3 of the complaint, there is clear averment that the check in question was issued from an account which was non-existent on the day it was issued, or that the account from where the check was issued pertained to someone else. As per a complaint's own pleading, the bank account from where the check has been issued was not held in the name of the appellant. Even in this case, my lord, even after knowing that the account is not mine, my lord, that the check is not mine, my lord, he has instituted this, my lord, NI proceedings, my lord. One of the
What is your relationship with him?
my lord, I had a relationship with him. That is 3 years prior to this occasion, my lord. I was involved with him in a land sale agreement, my lord, which was terminated, my lord, in the year 2018, my lord. And these proceedings have been drawn up, my lord, in 2021, my lord. 3 years prior to that land sale agreement has been terminated, cancelled. And I am not the buyer of the land, my lord. The land has been bought by some other person, and he had already executed.
What is the transaction maintained in the mentioned in the complaint in respect of which the check was supposed to have been issued by you?
My lord?
What was the transaction mentioned in the complaint in respect of which you issued the check allegedly?
I had not issued the check, my lord.
That is not the question.
My lord.
Question is,
As per
according
his
to the
allegation, my
complainant,
lord,
what is the transaction in
as
respect
per
of
his
which?
allegation is that I had issued this check in respect to that, my lord, land sale agreement, my, which was, my lord, done in 2018, and the land that was sold, my lord, was sold to 3 other persons, my lord, not even to me, my lord. And he had already executed that, my lord, land sale agreement and handed over the plot of land to the owner, my lord, to the buyer, my lord. That was in 2018. And in 2018 also, my lord, he had cancelled the land sale agreement that was with me, my lord, after selling the land, my lord.
What have you said in your reply to the demand notice?
Yes, my lord, that your lordship will find at page 28, my lord. On page 28, my lord. There I have clearly stated, my lord. 2018, my lord, the land was sold to Suman Acharya, Dr. Krishna Talukdar, and Hare Krishna Das. And also it para two, your lordship will find that a land sale agreement executed with me, my lord, was cancelled, my lord.
Yes.
My only submission is that, my lord, I am not for the, my lord, passing of the trial and trial, I am willing to face the trial, my lord. But, my lord, this 20% compensation amount, my lord, that may be, my lord, cost, my lord.
What is the provision with regard to that? 20%?
20% is, my lord, 143A, my lord. Under 143A, my lord. Is a, my lord, directory provision, my lord, not a mandatory provision, my lord. And upon satisfaction that the case, there is also a judgment of the Honorable Supreme Court, my lord.
Yes, we'll wait for some time. Let him come. We furnish the judgment. That regarding
Yes, yes.
compensation. Yes.
Lordship, hearing this case, your lordship. Krishna has been convicted on 12/8/2024 connection with PRC case 01 and 80 passed by the Central Ministry. Thereafter, he was been convicted for 1 year, fault of 1 month, and realization pay of 10,000. In the meantime, your lordship, he appeared before the court and appeal. Then thereafter, your lordship filed before this honorable court. Wrongly, it has been filed as an appeal, and registry has asked directed to file a criminal revision. Later is filed. In the meantime, he was been arrested. He has been, my humble son, that 1 year is there already, 20 days.
What is the sentence?
1 year, your lordship. Case 2. And judgment passed on etc. Chief judicial measure, your lordship, permit me page 2, your lordship. It is placed by the accused 24 by IPC. Sentence to undergo 1 year and to pay fine of 10,000 only. In default of payment of default of payment of undergo another 1 month and highest for the pay for the suspension of the sentence and under under section 473 of Bharatiya Narcotics. I have a 9 years old minor child. Yes. Alone is alone right now. Like the victim, your lordship, PW4 been married
You are already for 1 year.
only for 1 year,
No, you are in jail for how long?
3 months. I was arrested. I was in jail on 2/8/2025. Case 16. In the meantime of filing of revision here. Case 16.
But is there any provision for suspension of sentence in a revision?
So,
473. Hello.
470.
PNS. No. PNS. Follow. That 473 relates to power of the government.
Lordship.
What has it got to do with the court? Yes, prosecution, is it permissible?
Next are 522 yellow.
Huh? Page?
Page 72 yellow. I had filed initially criminal appeal.
That obviously doesn't lie. There is no second appeal in criminal cases.
File.
So you have filed for revision. You're asking where is the provision for suspension of sentence?
It revision, it don't comes under 389.
of sentence is that is with regard to appeal.
Yes,
And another part is the bill.
if it is for bail, suspension of sentence comes under 389 subsection of C. For in bail provision, here it is not maintainable for criminal.
No, he has filed the application under 473.
470.
That is the power of the appropriate government to
Yes.
suspend the sentence.
Lordship may come to section 397.
This is under CRPC or 2018 matter? CRPC.
Yes.
Your case is not covered by BNSS this year.
389 CRPC.
397 calling for records to exercise the power of revision.
Three?
397, this is a provision for revision. Yeah.
So this is the provision under which you should have filed a revision.
Lordship,
Has been also condoned your.
Lordship, if anything counts the trial court just Lordship, counts legality and infirmity, then only revision lies. So here only he has comes for suspension of sentence.
Where is your main revision?
Lordship,
This is
this is
443.
Lordship.
The impugned judgment at phase starts from 31. Why not?
Lordship. 31. And except 3 year old.
That it ends up at Lordship.
60 year old. Given person of the order at 58 year old.
58 Lordship.
Fair year old. In view of the conclusion made above, the accused convicted under section 24 of the IPC, and accordingly, the convicted sentence undergoes imprisonment of 1 year and to pay fine of 10,000 only under section 24 of the IPC, and in default of payment of fine undergoes imprisonment for another 1 month, and a realization of the fine amount, and same shall be given to the victim PW4 as per section 57 on B of the code of.
Session. It is-
Yeah.
CJ. Then appeal lies Lordship,
Appeal has been dismissed.
that has been dismissed.
This is
we
a
should-
case of, this is a judgment of 2018.
Then he should come under
Lordship.
section.
Huh?
Seven.
Case of 2018.
Lordship.
So it's CRP, it will be covered by
CRPC.
CRPC.
Then he should
You have come under
three.
BNSS. Firstly, you wrongly come under appeal, then
Lordship.
you come under the wrong act. By that time, sentence will already be over.
Then he should
Lordship.
come under section 387.
Yes, you should have come under 397 only.
397 Lordship.
I have mentioned your lordship, 97 when Artswell CRPC, this will be a. Artswell under section 389 CRPC.
Yeah.
My cost title, IA 106.2. Yeah, your lordship.
I for what?
Suspension.
Then it has
Or-
come on the wrong section. Yes, suspend of sentence 89.
389, it is there, Lord. I have mentioned in my,
But in the main revision petition, he has given a wrong section.
but lordship, in the IA of 1069, I had mentioned here.
But in the main revision petition, he has come on the wrong.
E89 will not come in, it is not an appeal. Only 397 only.
397.
That he has mentioned 438, 442 BNSS, read with 528 BNSS.
Lordship.
There is no
I think
reference
there
even
is
to
criminal
CRPC, but
machine
the
documentation.
conviction is under IPC.
Earlier, initially, your lordship, I had filed an appeal on the section, the same section, but the honorable court has directed modified and corrected. Accordingly, I have modified and corrected. Then accordingly, I approached before this honorable.
If and correct what?
That appeal was not maintainable under
Obviously,
case 72. I have given the
did the court ask you to modify and say BNSS instead of CRPC?
Annexure 5 in the main appeal, your lordship. Criminal appeal mine is 6303/2025. That is a filing number.
That was your first mistake. This is your second mistake.
Yes.
And thereafter, your lordship, if lordship permit me, I can make this that. Then I can I will amend it. But the entire case, the speed of the justice that your lordship, I've been convicted for already been 3 months.
When was the date of conviction?
12/8/2024, your lordship.
12/8?
12/8/2024, your.
Yes, and when did you file the appeal?
I had filed your lordship this appeal on 3/7/2025, your. After dismiss of the session court.
Hmm.
9 days default, and this honorable court has condoned the delay. Then thereafter I filed.
And how come you were arrested?
Lordship,
How come you were arrested? Were you not on previous bail?
Lordship, in the meantime, I filed. before
Your
the
appeal
honorable
was
court.
dismissed.
Then previous bill by the
So,
learned
you ought to have come immediately.
prosecution, my learned advocate ought not have been done this.
In any case, you cannot blame others for your plight.
And I am
Don't-
totally responsible for that. So that is the statement I have been mentioned here, lordship. In my case, here, lordship, in paragraph 26, page 2016, your lordship.
Already heard learned counsel for the petitioner. IA. This is an
106.
application. Stated to be under section 473 BNSS within bracket erstwhile section 389 CRPC. Seeking suspension of sentence imposed upon the petitioner by the judgment dated
12/8/2024.
passed by the learned session judge Jorhat.
No, lordship, CGM.
CJM.
CGM Jorhat.
Jorhat.
No, appellate.
District session.
That is what I am saying. You are against the appellate judgment now.
Lordship. That is judgment on
Have you impugned that or not? Or have you left it out?
2025. Case annexure 55. Criminal appeal number 24/2024.
Not mentioned in the cost.
There.
You have no prayer.
No.
In the main revision, look at your prayer. Why the impugned judgment and order so and so passed by the CJM Jorhat? What happened to the appellate judgment passed by the session judge? Nothing in your prayer. Sorry, we can't entertain with so many mistakes.
I may be amended, your lordship. But I
Up
will.
to you, we don't know.
Let the matter may be adjourned, your lordship. I will direct it.
On the prayer of learned counsel for the petitioner is the matter again after 2 weeks.
I'm deeply obliged. Wait, please. Let is like, yeah, goals, what has happened is some money person by one amongst Paul, by one gold testing unit is a gold. That amount from Himang's Paul the police has seized, and after that the police have come is stopped and also seized gold. Now in this regard, your lordship, we have come before this on court for Jimma, both the Jimma of gold and money was rejected by the trial court. Therefore, we came before this honorable court initially with the goal. The goal Jima has been given by this honorable court by the order dated. Your lordship find that order at page 41. And now we have come, then thereafter, after this order, your lord, we again applied before the trial court, sorry, not 41, it is at page 65. 60.
Some report was called for.
That record was called for earlier. with
No, by
regard-
last order.
Yeah, that was, they came up with the record saying that already gold has been handed over. With regard to this money, that has not been taken care of. Your lordship, what has
No,
happened?
no, in the order dated 28/5/25, it is reflected that in the report submitted by the IO, so and so, it's placed before the court, there is no indication as to whether the Jima of the cash is required during the trial or not. Call for a fresh report from the IO.
That I don't, know, but as per their report, it was stated that the gold have been.
You don't know about the order passed.
No, I know about that, because it was earlier directed, but they came up saying that if, in fact, placed an order saying that the gold has already been handed over as per the direction. With regard to the cash, that also, your lordship, I'll.
See, learned PP, so many directions. First 28/5, then 16/6. Needless to clarify that report as called for shall be positively filed by the next date of listing. Then 25/6. IO has sought time. Another date to obtain the report. No, not IO has sought time. You have sought time for on behalf of the IO. Then
I have.
not you,
Okay.
PP.
In fact, this was searching it. I'll have not yet started, but. And in fact, one part has already been granted. Second part.
What is the meaning of this? You were there, Mr. Burwa. 25/7/25. First part is regarding scan copy of TCR. Then there is a line report received by Mr. Burwa, learned additional PP to be retained for placing it before the court on the next date of listing. What report was that?
Maybe maybe in the record, my lord.
Then 4/8/25, Mr. Sharma, learned additional PP, has sought a last opportunity of 7 days to place the report. 12/8/25, Mr. Kaushik, additional public prosecutor, last opportunity, 10 days time to obtain the report. Who is this IO? Personal appearance. Yes.
Whether it is communicated or not, my lord. Well, after some time, my lord, I'll just get some inspection.
All right.
My lord, the IO has been communicated or not, that I have to.
If despite so many orders, if
Yes,
it has
sir.
not been communicated, then somebody from your office has to be taken to task.
That is what.
It will take up after some time.
See my senior colleague.
Item?
For time
22, your lordship.
22.
This case, we are challenging the criminal proceeding, your lord. We're praying criminal proceeding may be set aside and passed. Petition was filed and the protest petition is a complaint case and subsequently summons were issued. My respectful submission, your lordship, that particular protest, a complaint. Is the major first class ought not to get is current summon pass it.
You are respondent number 2.
after some
Wait. Yes, next.
On observation given on last order date.
Yes. You've gone through the records.
Record is received, my lord.
Huh?
LCR has received.
Yeah, that was received on the previous date, I think. Learned PP submits that since the petitioner is one of the main accused, she needs some time to go through the records.
Yes, ma'am.
That was 611.
I have go through the record, my lord, and there is a statement of one witness, my lord. His name is Nur Mohammed, my lord.
Hmm.
Kindly, because here's the person, my lord, who took the victim. Victim is his wife, my lord. Petitioner wife is number 4 wife. So he took the victim, my lord, his car. After that, my lord, she got missing. After a few days, my lord, her decomposed body was recovered, my. So lordship, may kindly peruse the statement of Nur Mohammed, my. I have flagged it.
What is the name of the petitioner?
Rafiqul,
Hmm?
Rafiqul,
Rofikul.
He has been named, my lord, in the FIR, my.
there are 7 accused. Out of 7, 6% already been released on bail. Yes, are ready to be committed law. Pending in
Under sections.
other
Hmm.
case.
There is clear implication.
Yes, case is serious. I'm behind the
Case is serious. Evidence is also serious.
lordship 7 month,
What?
7 month, 17 days behind our lot.
Not so long.
Have been just on bail, lordship.
Not so long for a case like this. Your own wife appears to be pre-planned. Witness is there.
He has been named in the FIR. He has been named in the
Yes.
FIR.
Face the trial, lordship, on any condition.
Of course, you have to face. Where will you go? Learned counsel and learned additional PP. This is an application under influence. Allegation as per the FIR Paragraph. Error. Submitted on behalf of the petitioner that petitioner has been behind bars for the last 7 months and he cooperated the trial if released on bail. What is the still charge sheeted?
Charge sheet, my lord, is fixed for my appearance of the accused.
Where a case has already been charge sheeted. Appearance means he is behind bars
He is behind.
for product. So next date will be charged.
Yes, my lord.
Co-accused is there.
Other accused person, my lord.
Co-accused
appearance
is
is
there.
complete, my lord. Then only.
Case is committed already.
Yes, ma'am.
It has been submitted and case has already been committed on perusal of the record. Appears that there is incriminating material against the petitioner to indication of a pre-planned commission of murder. They are having regard to the incriminating material available in the record and the gravity of the offense. The prayer for bail stands rejected at this stage. Hence this
Yes, well, application. Charge sheet. Aline, case number one of PRC case number corresponds 55 of the charge sheet number 35 oblique under section 448 70 fair page number
received.
The
CD?
scan copy received, ma'am.
fair page number that on night at around AM, the above this person come to our house of the introduce themselves as a person or the person the house of the victim is about 5 days tied to her hands and leg confine her inside the house. They then point a gun and forcefully rape me, accused person number one commit the act. Before having they lock the gate, gill gate from the outside, so that not that come out. We heard the sound of their motorcycle. They feel. On the hearing of the cries for help, nearby people come broken open the gate. Pass on of the said FIR. Katigor police station register a case as Katigor PS case number 600. Public.
Yes, what is the implication? Thing is there.
Implication is there, my lord. 183 is a statement of the victim, my lord, case implicated. Our question, my lord, question is that, my lord, they have, the victim has filed an affidavit, my lord. That is also in the part of the record. Whether, my lord, it can be compounded, my lord.
This is not a passing application anyway.
Not a passing
That question
application, but, my lord, they are filing this anticipatory bail application. Relying on the affidavit owned by the, my lord,
Actual
chief
fact of this
informant.
case, informant lost the FIR on the basis counter blast.
Huh?
Informant lost the FIR on the basis counter blast.
petitioner number one, mother of the petitioner number one lordship lost a FIR against the informant husband lord. That's why informant lost the FIR lordship. Page number 35, Annexa D lordship. May I read lordship? Comment Maloti lordship. With due respect, I beg to state that on 38/2018, above named accused person invited us to their house on the dead day. I, along with my son, wife, Kobita Sutia, my brother, wife, Santiboni Sutia, my grandmother, Rohan Sutia, went to the house of the said accused person to attend the invitation. After our arrival of the served us tea, shortly after drinking the tea, all of us lost the consciousness at the time around 1:30 p.m. Taking advantage of the unconsciousness that the above named accused person raped me, my son, wife, and my brother, wife. On the next day, 13/8/2018, at around 4 a.m., they woke us from unconsciousness state, put us together in the vehicle, brought us to Bodorpur, left us therefore the feeling the sense. In presence of my brother, wife, admitted the Karimganj Hospital treatment. I is still suffering the physical pain and trauma. We are helpless and come to court seeking justice. This FIR was caused by the petitioner number, mother of the petitioner number one lot. As a counterblast, comment lost the FIR lot.
Counterblast after 6 years.
No, lordship. We are lost the first FIR.
Yes.
Petitioner mother of the petitioner number one. Mother.
Your
lost the
FIR is
first
dated 3/9/18.
39/18 to 18 lordship.
And this is of
This is of lordship.
21/2/24.
26/9/18. 2018.
Then, my lord, incident of 26/9/18,
24
FIR is of 110/18.
3/9/18, I think.
FIR,
That is the type copy.
Type.
Information received
vernacular,
date
my lord, 110,
3/9/18.
my lord.
Huh?
Vernacular page number 26. It is 110, my lord, down below. My lord. Anyway, my lord, 110 or 310.
After 24 days.
No, that is you are referring to the
there
FIR of
was
the
a
present
against
case.
the accused.
Huh?
After 24 days, as a counterblast, the informant lost the FIR against the petitioner loss. After lodging of the FIR, both the side lawsuit settle the matter and file a affidavit.
This is
case-
Kaline PS case number 121 of 24, is it not?
Yes, lordship.
Huh?
Yes, lordship. Our PS case number, lordship, 605.
No, no, the present case,
present case, lordship.
Yes, Kalan PS.
121.
Yes.
The type copy date of registration is 21/2/24.
24, lordship.
Then?
Kaline PS outpost police station, lordship, under Katigor police station, lordship. At around, lordship, 24, a copy of order annexed here with lordship. Page number 28, 2020, 28, lordship, page number 28, lordship, order of the judicial magistrate.
There is two mentioned, my lord. One is category PS case number 666, my lord. It is page number 27, my lord.
This is, I hope this case, lordship, file application before the Kasar, Chief Judicial Magistrate Kasar, lordship, after hearing the both the side, lordship,
Thereafter, my lord, maybe it was transferred to Kalan PS.
Kaline PS.
Initially, it was registered as a category PS case number 666/18, my lord.
On 1/10/18.
110, my lord. After that, my lord, it must be, my lord, after my lord 6 years.
3/9/18 is the your FIR,
39,
original. First one,
first one.
3/9. Then second one of the present case, 24 days later.
Our FIR page number, lordship, our FIR page, case, our case number, lordship, 605/2018, lordship. Our fire set.
Both the FIRs are false, I think.
Sarsi that case.
Similar allegation by both sides. Each side claims that the other side committed rape on them at their own house. With hard learned counsel for the petition, additional PP. This is an application under so and so. The case is a charge sheeted one. and as per the FIR on the day of occurrence, that is 38/18. The both accused are petitioners here.
Yeah.
Bibu De Bishu. Both are petitioners.
They have been shown absconder in the search.
The petitioners entered into the house of the complainant, and after tying her hands and legs, forcibly committed rape upon her and dead. Sarah learned counsel for the petitioner has drawn the attention the court to Annexure D, which is typed copy of a FIR lodged by the mother of the petitioner. Who lodged this? Maloti Sutia?
Maloti is the mother of the petitioner number 1 Lord.
Lodged by the mother of the petitioner number 1 against the. Who is Bibude?
Bibude, wife of the husband of the informant.
Against the husband of the informant of the present case, alleging that when she, along with her daughter-in-law and sister-in-law and grandson, went to the house of the accused of the said FIR to attend an invitation. They were served tea, and after having the same, they lost consciousness, and thereafter the said accused person committed rape on the informant, her daughter-in-law, as well as her sister-in-law. Said FIR was lodged on 3/10/18, which was registered as Katigora PS case number 605 of 18 under section 120B, 328, 376D, 342 IP. Counsel for the petitioners, the FIR of the present case was lodged 24 days afterwards as a counterblast to the FIR lodged by the petitioner side. The perusal of the two FIRs could show that both sides have made similar nature of allegations against the other side. Having regard to the above, as well as the fact that the investigation is over, culminating in the filing of the charge sheet. There is no further necessity of taking the petition written. English prayer for prayers daily. Petitioners are directed to appear before the trial court. Is it committed? No. Not yet. Before the learned magistrate concerned. In the event of such appearance, they shall be placed arrest bail is 50,000 with security. The section of the FSC. Stands disposed of accordingly.
Right, please. Section item 54 also connected with item.
Who is appearing? In 54.
Both are out of same case. Same council. Item 54.
Then you come while 54 is called up. And the both are same matter, we'll hear together. Yes, next.
In item 39, your lordship, all the petitioners or other family members here, total custody 39 days. your lordship.
39?
39.
39.
Yes, 39. 25. Pardon. 25.
No, we are not.
25 and
25 is
other family
connected with
54.
54.
54. So we'll take it up when we take up 54.
Four Matu taken.
Lordship.
Yes.
But a status report, my lord. Case was fixed because, my lord, the earlier date was fixed for consideration of charge. As per the status report, my lord, charge has not been framed.
Not framed.
Because one of the accused person was not present on the
Peruse last file. Zakirus absent. Next, 15.
What happened on 1511?
Charge
Again, this fellow is Zakir Hussain is absent.
earlier occasion 2410 another Zakir absent. Same order dated 2410. This person already failed.
Can copy was already called for. It is received also. I
can
think.
be received.
Can go.
What is the allegation?
1511. Prior 1 day. Was it? 5/25.
Are there any order in respect of other accused? Have we three accused total?
3%.
Any previous application for other accused? No.
They got bail.
Huh?
In the Barnett. Bail prayer.
Who is this auto driver? Any statement of that auto driver?
Driver one.
Before missing my husband, an auto driver saw my husband along with Zakir Hussain and Baharuddin for the last time.
The page number 31 of the bail application is a part of the search, my lord. Let Lordship may peruse the last paragraph. Page number 31.
He's also only co-accused.
This is the materials, my lord, correct.
Since the complainant had mentioned about the auto driver, I should have gone after that, made efforts to get that witness. He's not there. They're just co-accused. And some phone calls. It hurt counsel for the petition. An application when by order dated 7/11/25 status report was called for the learned trial court. Learned Counsel petitioner has submitted copies of the orders dated 24/10/25 and 15/11/25 passed by the learned court below, which indicates that charges are yet to be consideration of charge is yet to take place due to absence of one accused. Para. The TCR as called for has been received. Perusal of same as well as charge sheet. The case seems to be based on the statements of accused. Besides that, no material could be pointed out which can be incriminating in nature or as petition having regard to the law is the law it down to Singh versus State of Economic Fair Daily 50,000 whose local securities of like the condition of deeply of
That allegation against the under 103 Millards, and I'm behind the bar Millard since 14/9. Today is the 7 days. But so the allegation is concerned, your logic will find it annexure 1, please translate copy as that page 11 Millard, 10 Millard started. That I informed the complainant, comment that was found in a cured Milan in the roads. So I informed Milan and they said that now they have arrested me.
What is your name?
My name is Milan Indrasen Yadav. I have informed Milan and I have been put behind bar. Anikula is at least.
PM report is there,
PM report is
awaited.
because of the thorough report. Because of. Yes, sir.
Without Visera, the report is there.
Without thorough report is there.
Report is there.
Things logic. The cause of date, that is number 1. And my lord, 67 days I am in behind the bar.
PM report. PM report. Give the CD also.
So whether my custodial detention is necessary at this 66 days I am behind the bar.
The name of the deceased? Biju Burman.
Yes,
Biju
Milord.
Burman.
Biju Burman.
Yes.
You have flag marked this, but these are not eyewitnesses.
But Lordship, the last relevant witness,
Tapas Sharma.
Lordship, last one.
Relevant. Kajal Chakraborty.
Last. Circumstantial evidence. The complaint. Some
Hers is just, she did not see any body as cleaned by him. There. That may be after closure of the shop.
Yes. Initially, no injury was found by the thereafter. Lordship,
Initially,
no witnesses has been seen by the other witness. Thereafter, Lordship, came out blood. Head of seats.
which witness had initially seen him lying there?
I am the person.
No,
Oh.
before that, I have flag mark. Somebody says him, somebody after closing the,
This last one is that owner of the pawn shop.
yes, yes,
She did not see anybody.
no.
Before that,
There
we
is
have
no
this.
direct evidence.
Huh?
There is no such direct evidence to the occurrence. But the circumstantial evidences, Lordship, chain of circumstantial evidence, there is a ring of truth that he has murdered. His
All right, we'll go through the CD.
Lordship.
But my submission is this. So if I do read, my lord, I will not definitely go and inform the informant that this is what has happened. So am I a fool, my lord, saying all this? Definitely I will be out of the place of. And also, my lord, is I am behind the bar. That my retention. So what my learned friend has said that I come to the bail me. I'm not on a trial. So there has to be some evidence inflating me. That's what my
Is there a report is still available?
Obliged, Lord.
Twenty. Lordship, 28 is related to item 3 of the supplement. Today morning, somebody, the counsel for the petition, taken time
Yes, for both.
for both. I could properly,
Yes, it is also marked as adjourned in my list.
yes,
Oh, or A2 timeout. I think he was there.
Friday. Along with that,
He was- $28 and 53.
28 and 53. Lord.
53 of supplementary
Okay.
list. Friday.
Friday.
May it please your lordship. I'm challenging the criminal proceeding, your lordship, whereby summons were issued to me on the basis of a criminal petition. My respectful submission that particular criminal petition is not to be treated as a complaint. Your lordship may kindly peruse page 26. FIR was lodged against me, your lordship. Subsequently, after investigation, final report was submitted on 31/7/2019. And then they have filed a protest petition. Your lordship may kindly peruse at page 26 on 1/7/2024. May I read the protest petition? Page 26. Your lordship.
Yes.
That the above noted case is pending in your honor court at the stage of appearance of the petition, and according to the petition, that the police has submitted final report in the above, that the petitioner is objected to accept the FIR submitted. Back of the case, investment Azhar is the petitioner in of 2 bigha covered by Bisana Nimukh Moja Hota Assam, where he was ready to cultivate the signal cross by giving himself iron. Some had criminally trespassed it, and they captured the land by fixing a banner of Puperun and demanding the land. The said the Xerox copy of the land file here with for you. Yet immediately after the said, the petitioner had looked an Azhar before the petitioner submitted photo of the Azhar that after the said all small and second President and submitted all the relevant tended after that and said the seat of commission bearing for trial. But even after the party the Xerox. From the above activity, person there are sufficient ground that they had first the land tried to by the for the reason they were able to criticize the case by the police. Also, may kindly note the prayer. It is therefore prayed that your honor may be pleased to admit this petition and further be pleased to take the final report submitted by the police and direct the police to investigate the case and after that submit the charge person Nirupam Sonwal, Secretary Manikanto, Donkey branch and pass according to the interest. Also note that there is no list of witnesses in this particular protest petition. Now your lordship may kindly peruse page 34, the order. The order was passed on 38 2024. The complaint is present. Statement under section 225 TNS recorded by of are the learned engaged counsel for the complaint. Peruse of the statements of the complaint petition supported by an affidavit. It appears that there is prima facie material of offence and 20 against and Bani Kanto. Accordingly, cognizance is taken under section 320. Nirupam Sonwal and Bani Kanto issue summons the accused person Nirupam Sonwal and Bani Kanto summons the accused persons complaint to take steps for April. Now, in this case, your lordship kindly BNSS, your lordship 223, section 223 of the BNSS. BNSS 223 of the BNSS. 223, your lord. 223 of the BNS, Bharatiya Nagarik Sanhita. Examination of the complaint. A magistrate having while taking cognizance of an offence and complaint shall examine on the complaint and the present the substance of such examination shall be used to write signed by the complaint and the witness and also by the magistrate, provided that no cognizance of an offence under section by the magistrate without giving the assuming this particular protest this is taken as a complaint, the subdivisional judicial method of not summon a notice or issue. That was not done. My first contention. Under section 2, and in this regard, there are judgments of the Honorable Delhi High Court and Kerala High Court and Karnataka High Court. I'm relying on the judgments. There 2025 SCC online Kerala 532. Para 7 and 8. Louis Anthony versus Judicial Magistrate First Class. May I read it? Para 7. May I read? Indeed, a radical change in procedure is brought about by the proviso to section 51 of 40 by the proviso of section 21 provide opportunity of section 2 does not recon the as a relevant factor for this account guided by the and the plain language of the proviso one of the bodies of the file should first in the account and we after in the of it. Right. I am also in complete agreement with the potential deal by the High Court of Karnataka in Agotas to stay clear the obfuscation to note the language described therein while taking cognizance. Could have with him the statement on oath. Then, if any witness are present, statement the taking of cognizance under come after the recording at that juncture and notice is required to the accused the proviso mandates grant of an hard. Therefore, the potential a complaint is permitted and it would be concerned. I mean the complaint which should be his. I mean the present and the substance of such. Right.
Yes.
Lordship, this is my first contention. The other judgment also, Your Lordship may kindly peruse. The Basagoda judgment, 2024 SCC online, Karnataka 90. Then I am relying on the other Supreme Court judgment, 2019 8 SCC 27, where it has been clearly stated the protest petition must fill the requirements of the complaint. Your Lordship may kindly peruse this judgment, 2019 8 SCC 27. Vishnu Kumar Tiwari. From para 35 to 43, Your Lord.
Para?
We have also gone through the protest petition.
Para,
from
para?
Para 35. Para 35 to 46. Mary, we have gone through the protest petition along with the counter affidavit. In para 2, there is a transport property. So this is the Your Lordship may kindly peruse page paragraph 43 from 43 on. 43. Mary, para 43. It is true. It is true that law mandates notice to the informant complainant where the magistrate contemplates accepting the final on receipt. On receipt of notice, the informant may address the court ventilating his final report. This usually does in form of petition. In Mahabir Prasad Agarwala versus the learned judge of the High Court of Odisha took the view that the protest petition is a of complaint and examining section 16 of the criminal procedure code. We, however, also noticed that in Kasi versus the learned court of judicature held in Abhinandan Jha, also what was not very clear as to the magistrate has. This observation not mean that every protected a private complaint is to obtain a complaint. A further examination is that if the magistrate did not did not specify all the content fine, not in a complaint. Finally, the magistrate has to on the magistrate no case without accepting final report or the case also primary. The protest petition serves the purpose of drawing attention to the materials the case diary and invite a careful and exercise cannot be held because the complaint. We may also notice that in Virappa versus Bhima Derappa, the High Court of Karnataka observed as follows: on the above the where initially the complaint was not filed by any complaint with the therapist, but was approved the police only and where the police after investigation have filed a B report. The complaint was protest, thereby inviting the take cognizance under section 191A RPC complaint. If it were to then, so the protest petition shall have to satisfy the requirements of a complaint as defined in section CRPC, and that should contain facts and constitute offense for which the learned may seek competence and CRPC. If it is to style as a protest without containing party that a normal complaint has contained, then it not be complaint is defined in section of the code. 2D complaint means any or in under this whether known or unknown has committed an offense, but does not explanation a report made by a prosecutor in a case after investigation and non-cognitive shall be in by who complainant. If a protest the requirements of a complaint, the magistrate may treat the protest as a complaint and deal with them as required read with section 2 of the code. In this case, in fact, there is no list of which does it in the protest. Here, it is to set aside the final report and to allow the application the final order. But we are not suggesting the form must entirely be of the question whether it wants to a complaint or able as a complainant. You will think that the protest is coming up the second exponent, the final. Since such unexpected the matter, in fact has not argued the bar that private husband should affect. It was very clear. The protest petition must be, if the protest is to complain, it must as per section 2D of the CRPC. Now, Your Lordship, there is another Supreme Court judgment, 2024 SSC online 821. Air 2024 Supreme Court.
Okay, let us admit it today.
Absolutely, Miller, but what I am on, they are without a stay, and I have got the entire certified copies of the proceedings therein, how they have been conducting there. Only thing is they are seeking adjournments. Here there is no stay, that is not proceeding. May I just pass it over, Miller? But she made with it, Miller.
This is the point of proceeding. Prima facie, we are satisfied that they does not comply with the provisions of.
Exactly.
I address your lordship on that, Miller.
No, we are at the stage of admission now. The prima facie case has to be made out.
Then I pray, Miller, lordship fixes a date in the near future, Miller, next month, and lordship may hear the entire matter.
Yes.
Instead of admitting it now and putting it
No,
with
no,
the Miller, let the matter be heard once and for all, Miller. Let us on the law points. Since on law, Miller, I raise on law points. Any day, Miller, next week, the week after that, Miller. Any day. Do not object to that, Miller. Even if this matter is allowed, it's better. Even if it's dismissed, it's better. Also being the developmental law on that point. Not even have it any other day. Since my uncle had expired, I may not be in Guwahati for a couple of days. I'll be back next week.
You want it listed in the admission column.
Yes, yes.
Hmm?
Not have it listed. We'll argue it out. We'll not pray for time, Miller,
Yes, Your Lordship.
on the law point.
Yes, yes. But on 29th, Your Lordship.
Before that,
Fix on 29, and because there is here before court, the trial is continued.
What will happen on 29th?
So it may come up before 29th. Your
only for the process, they have to.
Or Your Lordship may hear it today. I'm ready for the argument. Some
Listen
protection
to
will be
hear it.
granted.
We
The
have
protector may not be
This-
granted, Miller. Let
this-
him appear.
No, this case, Your Lordship, prima facie, the court, while taking cognizance, not issued notice, Your Lordship.
He's on that order whether summons could be issued or it has to be noticed.
Definitely.
If that is his only limb of argument, I'll address that point, Miller.
Definitely. No, that is not the only point of argument. There are other points also.
That is why it requires a full hearing.
Exactly.
Because if, or she may have
But
it
some
next week.
protection may be given.
No protection. Let me have it next week, Miller, before the date. I'll address your lordships on the law point.
Don't admit it. What is the point of hearing it?
On admission, Miller. Absolutely.
What is the difficulty if it comes in the hearing column on a hearing day?
Exactly.
But there may not be a stay, Miller. That's what I'm saying. If it's admitted, records are called for, things get delayed. What I'm on is that let it be fixed for admission, we'll finish it off on the next day. Since he's urging a point of law, I'll address on that. Only for the bereavement, I'm praying for 1-2 days.
Problem is we cannot invest so much time on an admission matter when so many bail hearings are lined up.
Lordship, we have it as a last item that day.
Okay, that is the understanding, then we'll take it up as the last item.
Absolutely. Other is to
After
fix it.
after the end of bail hearing.
Today, Your Lordship.
We have to finish the bail hearing,
Not today, Miller, any other day.
not today.
Not today, any other day as a last item.
But counsel for the prisoner at some length requires hearing. Is the matter again admitted on hearing day?
Wait, 26, the case is
25.
5 years. That to 5 it.
Hmm?
The date was examined.
What to do that?
That is why I'm praying that the protection may be granted 2 years.
So you have 25, he has problem 24, 21, 20.
But I'm predicting, and the case will be fixed for here, for the here. The only thing is that because the case will be
weeks for cross-examination.
We have
has not
agreed
been
to have it
done.
on a hearing. There's only, we are
Not-
only on the date. Agree on a date of next case.
Obliged.
23rd, Your Lordship. May I pray for 23rd?
Possible.
No problem.
23rd is Sunday. Yes, call the next item.
Obliged, Lordship.
Obliged. Last judgment I have submitted, my lord, is regarding to the section 143A, my Rakesh Ranjan Srivastava. So, at para 19, my lord, lordship will find the condition required, my lord, for my lord, payment of 20% compensation. My lord.
Just
The
a moment.
trial judge has to be satisfied, my lord. 19, paragraph 19, my lord.
এইটো আগৰ কেছটো থৈ দিয়া। Yes.
Paragraph 19, my lord.
Of
Of my lord, this,
Rajesh Ranjan.
Rakesh Ranjan Srivastava, my lord. Rakesh Ranjan Srivastava versus the state of Jharkhand, my lord.
Yes.
The exercise of power under subsection 1 of section 143 is discretionary. The provision is directory and not mandatory. The word may used in the provision cannot be constituted as shall. While deciding the payer made under section 143A, the court must record brief reasons indicating the consideration of all relevant factors. The broad parameters for exercising this discretion under 143A are as follows. The court will have to prima facie evaluate the merits of the case made out by the complainant and the merits of the defense pleaded by the accused. In our case, my lord, we have pleaded that the sake is not mine from the initial start, my lord, even in our reply, my lord. The second point, my direction to pay compensation can be issued only if the complainant makes out a prima facie case, my lord. Even after learning, my lord, knowing, my lord, that the sake that is bounced, my lord, is not mine, my lord. He has instituted these NIS proceedings, my lord. If the defense of the accused is found to be prima facie plausible, the court may exercise discretion in refusing to grant interim compensation.
Yes.
That is my humble submission, man. Already,
Yes.
my lord,
My lord, may kindly take up section 143A of the NI Act.
Nayak. Yes.
The heading, my lord,
Yes.
the heading reads as power to direct interim compensation. This power is with the trial court. Notwithstanding anything contained in the Code of Criminal Procedure 1973, the court trying an offense under section 138 may order the drawer of the check to pay interim compensation to the complainant. In a summary trial or a summons case where he pleads not guilty to the accusation made in the complaint, and in any other case upon framing of charge, the interim compensation under subsection 1 shall not exceed 20% of the amount of the check. Now we have to see whether in this case it is ordered beyond 20%. No, it is 20% only. So no illegality is there. The interim compensation shall be paid within 60 days from the date of the order under subsection 1 or within such further period not exceeding 30 days as may be directed by the court on sufficient cause being shown by the drawer of the check. If the drawer of the check is acquitted, the court shall direct the complainant to repay to the drawer the amount of interim compensation with interest at the bank rate as published by the Reserve Bank of India prevalent at the beginning of the relevant financial years within 60 days from the date of the order or within such period, other period not exceeding 30 days as may be directed by the court on sufficient cause being shown by the complainant. The interim compensation payable under this section may be recovered as if it were a fine under section 421 of the Code of Criminal Procedure 1973. The amount of the fine imposed under section 138 of the or the amount of compensation awarded under section 357 of the Code of Criminal Procedure shall be reduced by the amount paid or recovered as interim compensation under this section. Now, my lord, whether this is a revision application, whether there is any illegality or irregularity committed by the learned trial court.
Yes, we're on that question only.
Yes. Now, my lord, the learned trial court is vested with a power under section 143A to award interim compensation, and that should not exceed 20%. The learned trial court has rightly awarded 20% of the amount. Now, my lord, my learned friend have argued on the facts of the case. The learned court is now sitting over the facts, the seas of the matter, and these facts will be decided at the time of judgment. Now, my lord, here my lord arguing the facts before this court, whether that was his account or not, whether the check was issued by him or not, all these are questions to be decided in trial. Now, if we go on arguing on those points, my lord, and if this court gives any observation, that will affect the trial. These arguments, this is a very premature stage to make all these arguments. And his main contention in the main defense is that the agreement for which against which he had given the check was cancelled. So, since the agreement is cancelled, there is no legally enforceable debt. Now, my lord, thus I'll argue only one. I am arguing.
No, that is not his main contention. His main contention is that his account does not belong to him at all.
My lord, whether the account belongs to him or not, whatever,
No,
my
no,
lord.
I am pointing out what his main contention is.
My lord, in the trial court, my lord, what defense he has taken, my lord, he is saying, because my lord, in NIA case, my lord, where the question to be considered is whether there is a legally enforceable debt or not. In regard to that, his contention is that there was an agreement between the parties and subsequently that agreement was cancelled. And since that agreement has been cancelled, that sale agreement, so there is no legally enforceable debt. My lord, again, my lord, the fact pleaded by the complainant is that there was a land which he had given to the accused, the petitioner herein, at rupees 60 lakhs. And in that agreement, it was specifically mentioned that he may sell the land to any third party. And if he does so at any price more than 60 lakhs, that will be his, but he has to pay me 60 lakhs. And that agreement binds the complainant that I have to execute sale deed in favor of the party whom he brings. Subsequently, in the complaint petition itself, names of 3 persons has been mentioned by the complainant in the NIA case, that these 3 persons were brought by him and I have done sale deed in their favor. Since I have to do sale deed in their favor, my lord, that registered sale agreement has to go. Suppose there is a registered sale agreement between me and him. Now he brings another 3 persons for whom I have to sell part by part. Definitely, my lord, naturally, first I have to cancel this agreement with him and then I can do agreement, sale deed with others. So that was what was done. So, my lord, these are all facts, my lord, all based on facts. Now, my lord, this section 143A, my lord, takes care, my lord. If suppose he pays me that 20% today and suppose the case goes in his favor, he wins the case, he is acquitted, then the section takes care, subsection 4 is there. And my lord, if he wants to argue, my lord, records are before your honorable.
Records are before your lordship, my lord. My main
Records are before-
contention is that
So
is
let
the
me
stake
submit.
is not mine.
I have not completed, my lord.
143A doesn't come, my lord.
My lord, if he wants to argue, my lord, my humble prayer is that the order passed by the learned trial court is well within his jurisdiction. There is no illegality, no irregularity. And my lord, if my lord wants to hear on facts, then my lord, this lower court records, my lord, we will also go through the records, whatever is there, then we'll argue on facts, but that is not necessary, my lord. The trial court will decide. Any observation taken by this court will have an effect on trial now. So my humble prayer is that lordship may kindly not entertain the arguments on facts, because my lord, I am not arguing on facts. But if lordships,
Whether it is fact, whether it is law, argument has been heard. It is for you to reply.
I am replying, my lord.
That is all.
My lord, they are saying about some depositions and all.
We are going to dispose of the matter. So you have to say whatever you have to say.
My lord, the depositions which he have referred, my lord, is not with me, my lord. Just,
Question is before the
All
Yes.
right. If you have
I-
time for that, that is all right. You can.
yes.
But in that case, my lord, the
But
lordship may
I
kindly
cannot
grant-
dispose of the case in a piecemeal manner. That this part you do, this part you do not do.
Because, my lord, whatever facts he is saying, my lord, with regard to that, there is other facts which we have to plead.
But
And
the
my lord,
question is already
the
before your
application,
lordship, my lord.
the petition,
There is nothing to be argued, my lord. Already it is before your lordship. Man. Trial court, all records are before the lordship. Man.
my lord,
Nothing new can be brought before this court. Man.
with regard to
Whatever
the,
is there already is there, my lord.
my lord, if he
Lordship
limits his argument to the averments made in the petition, criminal petition, then we can argue. If he limits himself. But if he is arguing from the trial court record, my lord, then I have to also go through the record and take instructions. My lord, there is a
Lordship,
criminal
it is-
petition
it-
filed by him.
The petition.
I have gone through the averments made in the
Revision
petition.
is part of
I have
the
my
trial court record, my lord. What?
I have my limited instruction as with regard to the averments made in the petition. Anything which comes up at the time of hearing from the records, my lord, I have to take instruction and I have to go through it, my lord, to make submission. He could have very well pleaded all this in his petition, my lord, then I could have.
It is already
replied.
pleaded in my petition.
As,
Lordship may take
Yeah.
my petition also, my lord. It is already pleaded in my petition. Most probably they have not gone through the petition. And main issue
Now, my
that
lord,
is-
kindly
that is
come
to
to
be
the grounds,
contested,
my lord. My lord, grounds,
Main
my
issue to
lord.
be contested, my lord, is whether the check is mine. The check is not mine, my lord.
You have made your submission, not
Check
allowing
is
me
not
to
mine.
make
So
submission.
rest of the conclusion, my lord, 143A will not be attracted, my lord. And the judgment, my lord, I have placed before your lordship, my lord. It is very clear, my lord. Julius Sehgal versus Shamsher Singh.
He has pleaded that is not his check.
My lord, may kindly come to page 6 of the petition.
And already I have pleaded, my lord. In my demand, reply to my demand notice, my lord, I have let them know, my lord. The check is not mine, my lord. They have already annexed that reply, my lord, in the complaint petition, my lord. But even then, the trial court had issued this, my lord, compensation amount, my lord.
My lord, he has already made his submissions, my lord. This will go on like this, my lord. Page 6, my lord. Grounds, my lord. What grounds he have taken? Kindly come to the grounds, my lord. Ground A. For the main ingredients to constitute a check bounce case requires that the drawer issues a check to the payee for repayment of a liability which is in the instant case the petitioner is not the drawer. Now, my lord, who will decide this? Trial court, my lord. B. For that the petitioner has clearly submitted in his reply and initial deposition that he has not issued any check to the complainant to fulfill his liability. He can make any deposition, my lord, either true or false, needs to be proved in evidence. Then C.
That, my lord, trial
For
will
the-
continue,
you are
my lord.
interpreting, my
I
lord.
am
I
not on the
can
trial, my lord.
request him, my lord, this is not the
My
way to
point
make
is not-
submissions.
Trial will continue, my lord. My
He is,
point
my lord,
only on 143.
purposefully making interference, my lord. Purposefully is making interference in my submission.
Lordship is aware, my lord.
These
My
tactics we
petition
know,
is
we
fair
don't
in my
apply.
petition is, my lord, only for the order of the 23/9/2023, my lord, for payment, my lord.
Why are you diverting
I
me
have-
from my
I have
argument
not-
now?
I have not, I am not before your lordship for passing of the trial, my lord. I am only before your lordship for the order dated 26/9/2023 for the check, 20% of the check amount, my lord, has been directed by me to be paid. Since, my lord, the check is not mine, my lord. And now, my lord, during the trial, my lord, the bank manager have already, my lord, deposed before the court that the check is not mine, my lord. Account belongs to someone else, my lord. How am I, my lord? There is no liability on my part, my lord. And the first sentence of, my lord, 138 clearly states, my lord, that the account should be mine, my lord. Where the check drawn by a person on an account maintained by him, my lord. If it is not maintained by me, my lord, how NI Act proceedings can come? It cannot be maintained, my lord. But I am not on that, my lord. My only prayer is that the 20% compensation amount.
All right, we'll take it up. You come ready.
My lord, in that case, my lord, I am praying for my lord stay, my lord, of this order, my lord.
My lord, he has not allowed me to make my submission. No stay, my lord. Kindly, if there is has to be a stay,
Then, my
lordship
lord,
have to hear me. This is not the way he argues, my lord. He just interprets, my lord. This
Lordship
type
may
of
value, my lord.
interference is very bad, my lord.
Stay, my.
He have already made his detailed argument, my lord. When I am making my
Take
argument, he
patience,
should
my
have
lord.
patience, my
He
lord.
will, he will.
He should have
take
patience
his
to hear,
argument,
my lord.
All right, we'll have it on another day when you have it.
Trial court date is on, my lord, next week, my lord. On Monday, my lord, next.
You submit there that the case is in.
Yes, yes, my lord. Trial court case is, my lord, on 26th, my lord.
Hmm. So,
If lordship
now
continues.
what is it fixed for?
It's fixed for payment, my lord.
All right, take a date. All right.
Much obliged.
Grateful, my lord.
Sorry, my lord, item number 30, my lord. I have to leave the court, my lord. 30, my lord, perhaps CD has been received, my lord. Better maybe taken on Friday or Monday, my lord.
Monday.
I have some difficulty. Item 30. Monday. Yes. Monday.
Item.
What order did we pass? 17? Interim order, 17 interim order. Earlier to continue. Yes.
We have already tried to intimate with IO, given a reply. Kindly Friday, Lord. Report was sought for regarding whether
Is submitted that communication could not be established. The IO. Hence, place the matter on Friday
21.
for report of IO.
So in item number 7, we have got the instruction as per report. No case has been registered as per telephone.
Learned additional PP submits on instructions received that no case has been registered against the present petitioner. At which PS? Yes,
PS Nagaon P.
hence. It is hence closed recording.
I plead, your lord. Translated copy of FIR is on page number 11. I am accused number 3, Sanjay De. May I read? Yesterday on 3/10/2025 at around 5:45 p.m., the accused number 1 and 2 was proceeding with a vehicle from Kamalpur with high speed, and after reaching near Islampur, hit an auto rickshaw bearing registration number so and so from backside and thereby caused damage to it. Thereafter, they also hit a bike bearing registration number so and so, which was parked near Longai Bridge and also caused damage to it. Thereafter, they went away at a very high speed, thereby hit me and caused injury to me. The people near the place of occurrence recovered me and chased the vehicle and intercepted the vehicle near Vitor Bonamali. Then the accused number 1 came out from the vehicle and hit my leg with a rod. Caused
Yes,
injury.
PP.
No injuries there.
We have the injury report. Worship, all the injuries are simple in nature.
Hmm?
Simple in nature.
I'm not the driver, nor the
Third learned counsel for the petitioner. And PP. Then application and influence. The allegations for the FIR is that the present accused persons who were. What were you driving? Bike?
no, I was not the rider also. I was nobody. Accused number 1 was the driver. Accused number 2 was the
Pillion rider?
no in the car. They are in the car.
Car?
I am accused number 3. Allegation against me.
That the
that
accused
I
accused
interpret-
number 1 and 2 as named in the FIR were driving a car and hit an auto rickshaw and a bike, and thereafter hit the informant at high speed, causing injury to him, whereafter the accused persons were chased and intercepted. And after such interception, the accused persons assaulted the informant, causing multiple injuries. Is submitted on behalf of the petitioner that the present petitioner was not even in the pending vehicle and was a bystander. Alternate PP perusal of the injury report submits that the injuries on the informant, right?
Yes, Lord.
The informant were found to be simple in nature.
Person sustained injuries. All are simple.
Informant and others. Regard to the above prayer 20,000 condition here with IO 7 days.
If you do item number 10, I am the accused number 2. I have been granted protection also. I have gone to police station, recorded my statement. By order dated 3/11/2025, I
Same ही हम The paragraph P of order dated P11 agar submission to not prevailing in the তার জায়গাটা একটু দিয়ে দিতে একটু mission injury simple যে having regard to the afforded the pre-arrest bail is allowed. The order of interim pre-arrest bail dated P11/25 hereby made absolute upon the same conditions.
CDB stand by clock.
CDV submit.
oblige.
$25, 54 and 25.
Case diary received, my
Total custody 39 days. FIR is page
You
number
are in 25.
25.
Hakim Ali and two others.
FIR is
Yes.
page number 8. Your lordship, vernacular is page number 10.
Yes, PM report is there.
PM report, dear my lord. Cause of death is mother asphyxia as a result of antemortem hanging.
Suicidal.
Total 39 days in custody and 5 days delayed to. And these partners are other family members. For one is brother and who is mother. Third is auntie of the plaintiff.
Our learned counsel for the additional PP. This is an application under defense. The allegation as per the FIR is that on 7/10/25, no, 3/10/25, the informant received news of the sudden death of her of his sister. That is the deceased. And on going to her house, he came to know that there was long-standing family dispute. And during one such dispute, the deceased was assaulted on the head and killed. And later on, her body was hanged to make it appear as a case of suicide. Para. CDS call for has been received, including the post-mortem report, which indicates that the present is a case of suicidal hanging. In the meantime, the petitioner has spent how many days?
39 days.
9 days
My
behind.
calculation 40 days.
Huh?
My calculation
40 days. All right, 40 days behind bars. For having regard to the above, the prayer for bail is allowed. 50,102. Cooperate with the investigation. And
54.
54 is the
Who are you?
husband, my lord.
husband.
Husband.
All right, same order.
Blazul.
Your lordship. Yes, lordship, there are money in the accused person, lordship. And on that particular day, lordship, the informant asked them to come and meet him to get wants to return the money, lordship. As soon as they came, their lordship, and this FIR has been lost, stating that they tried to kidnap. Whereas there is the agreement and the civil suit also pending, and we have earlier we have filed a case before the lordship, the DCP lordship, Guwahati Dispute Circle Law. Already our FIR is also there, lordship, and lordship come up to the main FIR against whom.
Yeah, lordship, here in this case, updated case has not come, lordship. One status report from DCP was called for, has not come, and IO has also made a request. Because of his law and order situation, he could not update the sheet.
We'll kindly have a look at page 11, the FIR, lordship, whether the further custodial detention is required or not, lordship. That is the point, lordship. Page 11, lordship.
That will be come up only updated case, lordship. On 26, lordship, I should take for short date, lordship.
How many days?
So Lordship arrested on Lordship 27/10 Lordship, carrying a month.
20, 22 or 23.
All right, then 26th.
26.
And next, the case, Lordship, the same case, he was arrested, but he was not present in the place of occurrence, Lordship. He was in Arunachal Pradesh.
All right, you'll have it on 26th.
Lordship, on 20.
Updated.
Much obliged, Your Lord. Much obliged.
Lordship, Lordship has already heard the counsel for the petition of my.
I have not submitted everything.
My only, my lord, submission is that, my lord. In this case, my lord, charge sheet submitted on, my lord, 21/3/2024. Now, after submission of the charge sheet, my lord, by naming the accused petitioner, my lord, IO does not have any role to play, my. Now, my lord, the money which they have bring for custody, my lord, Dimma, my lord, that has been rejected twice, my lord. Rejection order is very much clear, my
We
lord.
have annexed.
Very much clear, my lord. And lordship may kindly peruse the, my lord, charge sheet, my lord. Relevant portion of the charge sheet, my lord, I have.
Where is the rejection order?
Rejection order, your lordship will find at page 67. This is the rejection order after the order of allowing the custody of the gold. This is at page 6. Kindly see the order. All of-
And secondly, my lord, the person who is, my lord, claiming Zimma, my lord, the current note has not been, money has not been seized from his possession. my lord. Money has been seized and recovered, my lord, recovered and seized from the possession of one, my lord,
Himanshu.
Himanshu, my lord.
Let me submit. Yes. Lordship, kindly take page 67. This is the order. The learned counsel has stated that the petitioner has been allowed Zimma of gold. Now, I have been already granted Zimma of gold by this honorable court, and he also be with the Zimma of cash, which has been seized from the co-accused Himanshu. It is stated that the petitioner is a goldsmith and deals with manufacturing jewelry as only one. He has requested co-accused Himanshu Paul to acquire a gold testing machine from Kolkata, and he has given a cash amount of 70,000 to Himanshu Paul. Deposit the amount in bank account of the distributor of gold testing machine at Kolkata, but he was caught on the way to the bank on so by STF police, and the money was seized from him. An affidavit to that effect has been filed by the accused Himanshu Paul, wherein he has stated that the money belongs to the petitioner so, and he has no objection if the Zimma of the money is given to the petitioner. Two judgments have been filed, one passed by the Honorable Supreme Court so, Gujarat, and the other one by Karnataka High Court in Netherlands. I have heard the learned counsel for both sides and perused the case record as well as the judgment filed by the learned counsel for the petition. It is seen that already petition with the same prayer have been filed twice by the petitioner, and both petitions were rejected by my learned predecessor by the order dated so and so and so and so. After hearing learned counsel, the petition were rejected earlier on the ground that allowing the Zimma of seized money at this stage may prejudice the trial of the case. There is no change in circumstance. Now that, your lordship, this case, it was rejected only on the ground that earlier order of rejection was there. That, your lordship, will find.
When was the charge sheet filed?
That was filed in
Charge sheet filed, my lord, on 21/3/2024.
2024.
Earlier rejection was,
Earlier rejection, your lordship, will find at page.
that was pre-charge sheet or post-charge sheet?
That was also post-charge.
Post-charge sheet.
That was also, here your lordship will find at page.
Where is the first rejection
64.
order?
Basic. This is the earlier order of rejection. Now what?
Where is the charge sheet? Charge
Charge
sheet is
sheet, I
there.
think.
Yes, charge sheet, my lord, it is in the scan copy
On the
record, my lord. I have, my lord, I have flagged the charge sheet, my lord. Lordship may kindly see, my lord. There is one pink color flag, my lord. Lordship may peruse that portion of the charge sheet. Yes, my lord, this is the portion of the charge sheet.
What is the actual charge against the petitioner? That was what I'm.
Your lordship, the FIR was lodged by STF alone. It was not lodged by any person regarding any theft or something. There was no allegation by anyone regarding theft. There was no FIR, nothing. It was the amount was recovered from Himangsu Paul. They registered a case that gold and the amount of cash has been seized. Gold is already been granted. Now cash, why they are not granting the Jimma to me, your lordship? I'll show the judgment also. Now, there is no allegation that there is some theft. There's no allegation as such that there is a theft, or there is no, nothing is there to show that this particulars are theft. And also, I'll show your lordship from the records itself in the writ petition, in the criminal petition, that how this money has been granted and why it has been granted. I have all annexed. Lordship will kindly turn to page first page 31. Just a moment. Page 31. I'll show you, Lord. Page 31 of the petition. He's a person who deals in this. Is the registration certificate, your lordship? Name is there. Trade name is also. This page 31 is the registration certificate of his, your lordship, trade. His name is there, trade has been there, address is. Now, your lordship will kindly turn to page 36. This is where the whole thing comes. 36. Where from the money? Now, your lordship will see here a quotation. This quotation is made in the box, your lordship, second box. The quotation for feature, gold scope, so and so, precious platinum gold metal analyzed. Now, this quotation is the next pages your lordship will find, amounts to page 38, 28,55,600. That gold machine, your lordship, whatever is required. But page 38, your lordship will see it comes to 28,55,600. This is the amount of the quotation. And all the quotations have been granted here in page 39, has been stated here with regard to the whole issue. Now, your lordship, what happened? Thereafter, your lordship, this Himangsu Paul was paid some money. I have stated that it paid some money to deposit it in the account of this particular bank account of this particular company, and police has arrested him. Now, this money he in page 45, your lordship will find affidavit by Himangsu Paul saying that yes, this money is money of X so and so, and I have taken the money and it is his money. I took the money to deposit it in a particular account for Kolkata with regard to that. He has filed an affidavit. That is also reflected in the order. Now, your lordship will see this amount at page 48. This petitioner is a HUF Karta, and he has all throughout, your lordship, given his record has been given with regard to the financial details. From page 48 onwards, your lordship will see up to page 54, all the 55. All financial details have been given. He's been dealing with all these, your lord. And said, then, your lordship, what happened? Your lordship will find at page 65. All these pages, your lordship, his financial dealings have been stated by CA. Everything is. But the chartered accountant has given all the amounts of liability. Now, your lordship will kindly turn to page 65. I would like to point out the order. This is the order on 4/3/2025. By this on report, the second para onwards, this application on so and so challenging the order dated passed by the magistrate, STA case number 6 custody. In that case, it was gold. Cash was not filed at that time. Now, your lordship will kindly see, it may be stated, second part, your lord, para 3. Para 2 is with regard to the gold, para 3 with the amount.
it may be stated the police recovered an amount of so and so from Himanshu Paul. Later on, it was presumed that the petitioner wanted to buy his gold by paying money, and on that issue, the prayer for custody was rejected. Now, your lordship will kindly see at para 6. That is a quotation given. I will come to that judgment later on. Para 6. The court is satisfied that the money that was recovered from Himanshu Paul was actually given by the petitioner to buy a gold testing machine. The learned court below has erroneously interpreted the act and arrived at a incorrect finding. This court has already given a finding.
But I don't see any
But
reason
this-
being given for the finding.
Lordship,
I don't see any reason being given for the finding.
no, initially this court in a very short order has passed. And secondly, your lordship, I'll also produce the judgment of Sundar Bhai Ambalal. Here, your lordship, with regard to the money also, there is a portion has been stated how to give jima with regard to money. So I have made my submissions, your lordship, on the submissions made by me.
Were these materials before the magistrate, which were placed before this court, all these annexure, page 54 up to page 54, and then
Practically, your lordship, from the
Quotation.
order that was passed by the magistrate at page 67, seems these were placed. But he rejected the ground that earlier it was rejected by his. He did not state any specific reason for. Now, after this order, your lord, the court already, one part has been granted, the gold has been granted. What is the problem in not giving the cash, your lordship? And it was, otherwise also it was shown that the cash belongs to this person. There's no claimant, other claimants at all. And Anbalal Desai judgment, your lordship, I'm just forwarding that judgment. Here also, your lordship will
that
see.
part is regarding gold and precious. Any
Yes, I'll-
reference to cash?
Cash also is there. That is what I'm trying to show you. Para, lordship will start with para 10 of the judgment.
Yes.
Here, your lordship, heading is there to avoid the situation in our view. Powers under section 51 shall be exercised promptly and at the earliest. Valuable articles and currency notes. Both has been stated. Now I'll read them. With regard to variable articles such as golden or silver, so and so and so, they submitted that it is of no use to keep such articles in police custody for years till the trial is over. In our view, this submission requires to be accepted. In such cases, the magistrate should pass appropriate orders as contemplated under section 1451 at the earliest. For the purpose, if the material on record indicates that such articles belong to the complainant at whose house theft, robbery has been taken place, then these articles be handed over to the complainant after preparing so and so. These are the for the purpose, the court may follow the procedure of recording such evidence as it thinks necessary, as provided answer 451. And the bond and security should be taken so as to prevent the evidence being lost, altered, or destroyed. The court should see the photographs of such articles as attested or countersigned by the complainant accused as well as by the person to whom the custody handed over. Still, however, it would be the function of the court under 415 to impose any other appropriate condition. Now, 14 is the required. In case where such articles are not handed over either to the complainant or to the person from whom such articles are seized, or it is or to its claimant, then the court may direct that such articles be kept in bank lockers. Similarly, if articles are required to be kept in police custody, it should be open to the SHO after preparing proper panchnama to keep such articles in a bank locker. In any case, such articles should be produced before the magistrate within a week of its seizure. If required, the court may direct that such articles be handed back to the investigating officer for the investigation and identification. However, in no such circumstances, the investigating officer should keep such articles in custody for a longer period for the purpose of investigation and identification. For currency notes, similar procedure can be followed. So it was with regard valuable articles and currency. So same procedure has been described. And court has said that it is in their view, it should not be kept
No,
in the
paragraph 14 relates to where articles are not handed over either to the complainant or to the person
Anyways,
from whom such articles are.
the whole procedure
When it is to be kept in bank lockers.
that is with regard to when it is not handed.
But court in paragraph 11 specifically stated that it should be handed over. Paragraph 11 should be read conjointly, where it says that articles should not be kept in custody till the trial is over. And that is what the court said, number one. Second part is with regard to when a trial is, when a article is not handed over due to various reasons, then it should be kept in a locker. Now, here is a case where there is a specific application that the article is mine and kindly return it. There is specifically, the court has stated that after taking proper security, I'll give the security, whatever that bond can be given. There's also a judgment of the High Court of Clear. Now that exactly cash amount was also there. This is a Karnataka High Court judgment, so I was not placing. Here exactly considering this judgment, the court said that handing over that, but in that case the court has directed that indemnity bond has. They're ready to give that you. Why to keep the cash? Why keep? And in fact, you give one part, same case, same allegation. You give me the gold, you don't give me the money. And now you say that just because your predecessor has not allowed, I will also not allow. And this court, in the one part of the case, if I would have filed the gold and the cash together, it would have been, the same order would have been passed. But somehow we filed differently because
Where is the seizure list of it regard to the currency? It is there?
that is there. We have annexed at page 27.
Page?
Page 27. The handwritten is at page 20. That is the Karnataka judgment. That your lordship, they're also same thing, gold and cash.
Seizure list does not contain the serial number of the currency, does it?
Serial number is not. Serial number is not. Is an amount they have given, that amount of.
What is the, is there a requirement for the currency to be exhibited at the trial?
Required?
413 is there.
My lord, may kindly one aspect to the matter, my.
Hmm?
First and foremost, my lord, this is a search case, my lord.
Yes.
Secondly, my lord, if lordship goes by the FIR, my lord, I'll just take your lordship to page number 19, my lord. Under what circumstances, my lord, this currency notes were recovered? That has to be looked into, my lord. My lord, my learned friend has said, my lord, that he want to purchase a, my lord, machine, my lord, which will come from Gujarat, my lord. And petitioner, he is a permanent resident of, my lord, Rajasthan, my lord. He is not a permanent resident of Guwahati, my lord. He is a permanent resident of Rajasthan. Then machine has to be procured from Gujarat, my lord. And deals has been done in Guwahati, Assam, my lord. So now, my lord, lordship may kindly come to, let me complete, my lord. My lord, lordship may kindly come to page number 19, my lord. What is the prima facie material, my lord, before, my lord, registering of this case? Page number 19, lordship may kindly come to paragraph number 3, my lord. So I am not reading the entire paragraph, my lord. Paragraph number 3, my lord, middle portion. So we arrived at Khanapara and waited for the vehicle to arrive. And at about 10:30 a.m., we saw the target vehicle with a lone person moving into Guwahati city. So we tailed the target vehicle into Guwahati city in order to identify the receiver of the suspected stolen gold. On tailing the target vehicle, it stopped and waited by the roadside at Lal Ganesh for few minutes. When one person arrived alone on a Hero Honda Charisma motorcycle and stopped beside the target vehicle, the registration number of the motorcycle is so and so. It took both the suspect only 4-5 seconds to exchange the suspected stolen gold and the payback amount. My lord, if he wants to, really wants to purchase the machine, if he wants to give, my lord, 22 lakhs and 70,000, my lord. But he may come, he may call this person, my lord, to his residence, my lord. He can hand it over the money, can take the, my lord. Why under these circumstances, my lord? This is the first prima facie material, my lord. Secondly, my lord, Lordship has dealt with many, my lord, Zimma petition, my lord. First, my lord, claiming Zimma, the person has to show, my lord, that he is the owner of the, my lord, currency notes or vehicle or whatever may be the property, my lord. Where is the material, my lord? He is the owner of 22 lakh 70,000, my lord. He cannot claim, my lord. The money has been seized from another person, my lord. Now this person is claiming that I gave the money to this person to buy a, my lord, machine, my lord, or some tools, machinery tools, my lord, which has to be procured from Gujarat, my lord. And secondly, my lord, after investigation, my lord, search sheet has been submitted, my lord. Now, my lord, definitely, my lord, it can be given to him, my lord, but he has to show, my lord, that I am the owner of this 22 lakh 70,000 of rupees, my lord. I have taken this money from this account or from this person, my lord, and I wanted to purchase, my lord, the machinery from Gujarat, my lord, through this middleman, my lord. Where is the material, my lord? Money has been seized under, my lord, suspicious circumstances, my lord. It was bought red-handed, my lord. And secondly, my lord, now if Lordship, my lord, grants Zimma, my lord, then Lordship will have to quash this order, my lord, which has been passed by the Landed Trial Court on 5/5/2025. Now, while quashing this order, my lord, there has to be absolutely illegal, or my lord, or without any basis, my lord. Then only Lordship can quash this order, my lord, and grant them Zimma, my lord. If there is no illegality in the order of the trial court, my lord, then, my lord, how can this honorable court can quash this, my lord, order, my lord, grant them Zimma?
Now, regarding the money that has been raised by my friend, in note, they did not give any number in the note. Yeah, I have also not given any numbers in that note because it was the money delivered to be. Now, two things, Your Lordship, I have already shown one affidavit by Himanshu. He said that the money has been handed over to by the petitioner in the affidavit, Your Lordship, that I have annexed. That is there. Number one. Number two, Your Lordship, part of the money which I have handed over to Paul have been handed over to me by my brother. That is also annexed, Your Lordship. That is at page 60 in the affidavit. The affidavit is given by my brother, who said that I have given 10,50,000 to me in cash to buy the gold testing. So I was given 10 lakh by my brother. Rest of the money I have invested and handed over to him. He himself, the person who has taken the money, has not disputed that the money is not mine or something else. He has given in his affidavit that the money has been seized from me, but this money is of so. He has given it to deposit it the account of that particular company, which is not from Gujarat. It is from Calcutta. I have annexed that document at page Kolkata. That be yes. It is Gujarat, Your Lordship. That is not. Anyways, whatever be the reason, Your Lordship. But does it mean Kolkata, Gujarat, whatever it is? The company is not in Guwahati, number one. It is in Gujarat or Kolkata, wherever. So I have to purchase the machine. This person is an agent of that company. He has stated in the affidavit. So I've given the money to him. He is to suppose on the first thing they have to show. Is it a stolen money? Is it a theft?
My lord, for this purpose, my lord, our officer has filed charge sheet, my lord. The matter is for the trial court.
Whatever it
is. The trial will decide, my lord, whether it is stolen money or not.
Anyway,
Definitely, if it is not stolen, my lord, definitely, my lord, they will get the money.
Whatever, Your
But
Lordship.
regarding Zimma, my lord, I have got strong objection at this stage, my lord, because all the materials has gone against them, my lord.
Anyway, Your Lordship, this, my learned friend always have a strong objection. I know that. I appreciate it. Always. Not that the first time. Whenever I stand, he is very strong. And I like that. Anyway, that is a different aspect. First, I would like to point out. First thing is that two things were seen. One is gold, cash. In the case of gold, the same order, it was rejected. We came before this honorable court. Honorable court granted us Zimma. In the case of cash, we did not come before this honorable. Now we have. Fine. Now, what is the difficult in giving me the cash amount, if at all? Because we are ready to give a bond. We are ready to provide because there is no specific number of that notes so that it has to be produced. These are the specific.
Where are the notes now?
8 notes or something like that.
It is the treasury, my lord, because we have deposited, my lord, because the 22 lakh rupees, my lord.
So that is it. Why should my money, if
That
you
is
have
the-
got
that will be-
let us
then
say-
there
It will
is-
be proved during trial, my lord, because the person who has, if the
No,
petitioner has
since-
given this money, my lord.
Since the IO while seizing has not noted the serial number, and you have deposited the money in the treasury,
My
it
lord.
has lost its identity.
Yes.
It is not kept in a locker. It is merged with the government fund.
And
Yes.
So there is no way you can reproduce those specific notes in court at the course of the trial.
Yes.
That yes, these are the notes we have seized.
But then, my lord, with respect,
Then-
I'll take extraction, my
No,
lord.
what
Whether
instruction?
money has been, my lord, the number of the currency note has been recorded.
No, it has not been recorded in
Then we'll
the
take
Caesar
instruction
list.
in
It
this,
is
my lord,
stated.
then, my lord.
There's no record. of
Whatever lordship has raised this
Just
question, my
because
lord.
of that,
This is
Your
correct,
Lordship,
my lord.
I'm not going to. I have been waiting for so long. They don't bring the report, nothing else for so long.
No,
Today,
report, my lord, I have already submitted,
what
my lord. After
was-
filing
what
of the search sheet, my
that
lord,
you could have.
I have
What was
not
going
been informed.
through
Now the
my
question.
mind was that even if the Caesar list serial number is not there, if the money is physically available, then while granting Jimmar,
Money
that
may not
exercise
get-
can be
money
carried
may
out
not be, my lord,
of
may not
noting
be.
down the serial numbers and then later
Exactly.
on
Exactly.
the condition that the petitioner cannot dispute it at the trial.
My lord,
But if it is deposited in the treasury, that
Then
option is
nothing-
also.
my lord, my humble submission, my lord, whether.
It has no use for the purpose of the trial now.
Then, my lord, I'll take instruction.
All
but
right,
let
take
it-
one instruction.
Yes,
Fine.
let it come on Monday, my lord.
Not Monday, Your Lord. Let it be on Friday. Why should we wait for so long?
Where is the money?
He's
at?
taken the
I'll take-
instruction at 2 p.m. So he can
No,
take
no, my
that
lord,
date.
I have nothing to take instruction, my lord, because when I have
It is
gone
nothing to take.
No, my lord,
instruction.
when
Why
I have,
should we-
Try on
when
Friday.
when I have gone through the
Yes,
case, scan copy record, my lord, then I came to know, my lord, the matter has already been charged, my lord.
That
After
is
the
why-
charge, my lord, what
Once
is
the
the, my lord,
investigation is over, what is
role
the
of the
necessity?
investigation, my lord?
And secondly, if this money is given to this person here, what is wrong in that?
Wrong is
And
that
I
definitely
will
it is
give
charged,
the- I'll
case, my
give the
lord.
bo- bo-
You
bond
might
and
find
everything.
mentioned in the charge sheet itself what has happened to the money.
Yes, my lord.
Look at the charge sheet, is it there?
Is there?
Charge sheet is there, my lord.
Any
but it is
mention
not-
of
No, Your Lord.
it is
where
not
the money
there.
has
I'll
been
take
deposited?
instruction, my lord. Let it come Monday, my
No,
lord.
Friday, Your Lord. Let it be.
Let's not haggle so much over.
That's the, it should not be in it. I never make such.
No, I'll take only instruction, my lord. Where is the money at
taking
present? my lord?
instructions.
What happened between you two? You didn't invite him for your birthday?
I don't know. I don't know. I never. Lordship has not. I've never appeared with him. Today is the first time. Next time also, Lordship will see. This is the way. Every time he pays.
I'll take instruction
This is
only
not
regarding
really
the
the way.
whereabouts about
Actually,
the money, my lord.
Court as a.
All right,
Public
let's
prosecutor,
stop there. Okay. All of us have been together at some point of time.
No,
Let
no.
us
I'm not
forget
against
that.
anybody.
Yes.
I will never be. But I'm trying to point out what is the
Yes.
use here. Just making because one part has
All right,
already
you
been
try on
done.
Friday. We'll see.
Yes,
if you
Friday.
can't get- Hardly- sir. At length. It takes time to obtain instruction as to the the location of the seized currency notes and as to whether the same has been deposited in the treasury is the matter in on Friday. Yes.
How lies?
My lord, case that has not come, my lord.
Well, charge sheet has been filed as I know. PRC has been started. I have received notice from the court. And next date fixed on 3rd January for appearance of the accused. I am on interim bail, my lord. On the 3rd of January, I will appear before. I have received notice.
Will you appear and apply for regular bail there?
We'll go and appear till then, my lord.
Till then, already. Learned counsel for the petitioner submits that charge sheet has already been submitted in
I am
the
on
case
interim, my lord.
and the petitioner has received summons from the court and the next day is fixed on 3rd of January 2026. Submitted that the petition shall appear before the learned court below and apply for English. The instant petition is disposed of with observation that as in when the petition appears, that the petitioner shall appear before the learned court below the date fixed. In the event of application for bail being filed, as till then the interim order passed on dated
28/2/08/2025.
shall remain in force. Petition stands disposed of.
Not a.
Already
is not-
CD not received is to reminder interim order passed earlier to.
Four.
Updated CD,
Interim is there, but this person's statement is not there, Lord.
updated CD is not available. Placed again on
Interim আছে December
interim order passed earlier to continue.
edit.
CD was called for in this case. Around
Charge sheet submitted, Lord.
Charge sheet. What?
Charge sheet number 341/25 dated
Want to appear there or what?
09
restricted
2025.
already they are an interim lot, but effect of like
Oh, you have to adjudicate, we have to call for the.
there is already lot cases against the informant, my lord. Case is pending, trial is going on. Filed several cases indicating that they are going to file false cases against us. Entire family has been dragged in this controversy. While granting interim protection, your lordship was to record that
Nature of the allegations are not that. There's outraging modesty and kind of.
Charge sheet has
It's necessary to keep it pending.
Lordship, as well, it is charge sheeted, Lordship. They need to appear before the trial court, Lordship. But
we'll
it
face
is
the
charge
trial, my
sheeted,
lord,
Lordship.
if we are named.
What?
Appear and face the trial, man. Not that we are running away. man. Only thing this
He
protection
can
will be
appear before, Lordship. Until his appearance.
lordship granted interim. It should be paid up. But
Interim
what is
asset-
the harm for the
Interim asset.
no interim?
That is what, because of the nature of the had it been some serious allegation, Allegation, sir.
Lordship, Lordship. I'm not aware, Lordship, actually, very much.
Nine. Four. Submitted by learned Harsh has already said, right?
Right, Lordship. 341 stroke 25 dated 30 dot 09 2020.
Sir, I have figured nature of the allegation. Then there is no necessity of taking petitioner's custody with the fact that church within the order of interim period is still dated 5/9/25. I made absolute provided it is regularly attend the trial if any petition is for case it was when number two.
Yeah, please. 480 Feb. Records the
Receive
Record series.
My lordship, records have records. In the medical report, it makes records complete allegations as per the FIR.
what is the allegation as
The
per the
allegation
FIR?
As per the FIR is that, my lordship, take your lordship annex 1, page 11.
Yes.
My lordship, the main it starts from paragraph number 2nd. I start from first. Same day, the medical exam
One thing also important, Lordship. Here it clearly stated that on the date when medical examination was done, she was going through her periodic cycles, Lordship. Because of that, she cannot, after she was called after 7 days. So it cannot be ascertained, Lordship. After 7 days.
kindly be medical.
And it's because of that, Lordship.
It seems
paper.
Two other women were there with her. Their statements have been recorded.
It is recorded, clearly implicated. I have flagged. Last few lines, Lordship. First statement, few lines, last. Other witnesses are also there, Lordship.
Other witnesses
Other witnesses also there because other person are also there. They have also stated the same.
in the house.
Lordship.
In the presence of so many people.
Yes, Lordship, they
You
have
went
stated that. They have stated like that, Lordship. Our statement is also there, but it corroborates with other person.
Team spirit.
Hello. Well,
Where is it? In the medical report, it is stated why she could not be.
Yes, yeah, Lord.
The IO said that no injury found.
look, I go by even the search also repeat.
If Lordship,
Opinion is there.
Charge sheet submitted.
Yes,
Charge sheet submitted.
and in the charge, the IO, my lordship, at page 8, charge sheet has stated clearly court of the opinion.
Before the opinion, Lordship,
I may be wrong, subject to correct. My lord, date of exam was same of, I may date of exam same was 17 70
Where it is on the first page.
Lordship, in the next page, back. The middle, somewhere in the middle, Lordship. Not in that page, Lordship, at the back of the first turn page. Lordship.
And this is blank.
Lordship, may I, if I may allow to, Lordship. It would be. I found somewhere, Lordship, I will.
exam date of exam. It- my-
In the FIR, it is said with the two companions, they were showing daggers, but I found somewhere in the CD that they were standing outside. All right, since charge sheet has been filed, is the point now.
Our statement are dear Lordship, 180, 20.
Somebody, some witness said that they were outside.
No, some, the lady Lordship.
No.
This person's name is dear Lordship, it's Nazrul.
Hmm.
He has committed the.
Yes, his name is there.
Some are outside.
They were outside.
It is dear Lordship.
So inside were other women. How were they threatening them?
Lordship. Otherwise,
Lord Learned Counsel for the petitioner, also Lord NLPP decision application. Here as well. The allegations against the petitioner is that he, along with two of his companions, forcefully entered into the house of the informant and tried to take her away from the house. And thereafter, all of them removed her clothes and had sexual intercourse with her against her will, while the companions of the accused were threatening the other two women with weapons. And when the daughter of the informant screamed, The accused fled the scene. The case has already been charge sheeted. Around perusal of the record, appears that there are contradictions in the versions of the witnesses with regard to the presence of the companions of the accused. As some witness stated that they were outside the house. Where it is submitted that there were other women, daughter, children of the informant present in the house, and it is not believable that the accused person would be able to commit the aforesaid act under such circumstance. I find force in the submission having regard to the fact that charge has already been submitted. In the present facts and circumstances, it is not necessary for the petitioner to be taken in custody. Accordingly, the pre-arrest bail is 20,000 security.
Only few submission lots. Our 183 statement is, sorry, lots, one statement is implicating lots. In my humble submission lots.
And it is
I'm
with reference
objecting
to
on
the
that ground.
statement of the informant recorded under section 183 BNSS implicates the petitioner and therefore opposes the prayer for pre-arrest. Yes. Provided that the petitioners regularly attend the trial if one commences.
So bless me.
Last correction. Say,
Yes,
Is not available. Lord.
how many days in custody? This is Abby.
yes, your lordship.
Friday. When?
Lordship on
Which station?
Lordship on Rangya.
Okay, Monday then.
Lordship on 28 or 27, Lord.
All right.
27.
Did he not again? No.
In led
After
in
10th of December. Did he not right? Did he not raise the matter on the prayer of learned counsel for the petitioner? Raise the matter on 10th.
10th or after.
And
That for 82 application, and the case charge sheet already lordship, and trial for already started. And lordship, the filing charge sheet lordship, my name is Tony on absconder in the charge sheet lordship. And declare this case lordship kindly for a moment for case number 90 FIR lordship. There is five person is accused indicated in this case, and my name is serially 5, and the FIR name is for 1 had love affair with informant, and subsequently moved the informant at Bangalore lordship in his working place. And after 4.5 months lordship, and she returned and laws and FIR against the 4 numbers of accused, including. In this case, Lordship, petitioner police never visited the house of the accused person, even the accused person most of the time is staying in his house, permanent resident within the jurisdiction of the petitioner, Lord. And my legal submission will be appear in this case and face the trial, Lordship, and any condition may be imposed. And otherwise, Lordship, section 370D, and that will not come, that because the love affair with the FIR number 1, subsequently they got married, and after 4.5 months, returned from Bangalore to his hometown and lost the. Even then, Lordship, I have very clearly mentioned, Lordship, kindly come to page number 7, para number 5, Lord. The part of the FIR, Lordship. Very briefly, I have very specifically mentioned. And the incident took place on 8/8/2017. And the on that day, Lordship, the accused number 1 took the informant at Bangalore. Subsequently, she returned from Bangalore on 14/10/2017. And after that, Lordship, 9/1/2008, Lordship lost the effort. So as per the instruction, Lordship, only love and subsequently FIR accused number 1 and the informant having love affair, and they got married, but subsequently their marriage is dissolved. And in this regard, Lordship, the FIR present petition, Lordship, and it was a labor and it was also at Bangalore. But they took initiative to continue their conjugal life, but they could. Otherwise, after 4.5 months, Lordship, at the time, Lordship, and it was confined to the house, a rent house, Lordship. There are other.
You are, what are you doing in Hyderabad? What is that place?
Lordship, and Bangalore, Lordship.
Bangalore.
Lordship. I am also labor, Lordship. And I may be allowed to
Yes.
share for this. Otherwise, consensual, Lordship.
Both are there, forcible and promise to marry.
Both,
Both are there.
but he cannot marry both. So my lord, such that case, my lord, relevant portion is page number 34. Second paragraph. So, Lordship, there are some allegation against the Sattar Ali, my lord. My lord, her hospital for termination of her pregnancy, etc. my lord.
Here she says he was working in a factory for 2 months, 15 days. And on the other hand, she is kept confined for months together. She's- And the names are also different. Before police, she stated this Morzina Nessa promised her a job. And 164 statement, she says this other person called her. He was called to Bangalore by accused person, Sattar Ali and Nazrul Islam. 164. 161, she was called by Morzina Nessa Aduri.
He was called by 1 and 2, my lord.
No, as your page 34, second para. Third line, 161, in statement, victim stated she was taken to Bangalore with promise of job by one Morzina Nessa. Down under 164, she says Sattar Ali and Nazrul Islam.
Yes.
Hard learned counsel for the petitioner. Additional PP. Application of facts as disclosed during investigation heard that the victim was taken to Bangalore on a promise of job where she worked in a factory for 2 months, 15 days. And during this period, accused Sattar Ali and present petitioner at the name of Nazrul Islam committed rape upon her, because of which she became pregnant, and later on accused Sattar Ali took her to a hospital where she was forced to undergo abortion. It appears that the version of the victim in her FIR and her statements before the police, the magistrate, differ in material particulars and contradict each other. Para regard to the proceed facts. And the fact that has already been the retention, the petitioner custody necessary. The foresaid facts are accordingly allowed. Same parties.
PRC case number 190.
This number is there, I think.
Lordship. PRC case number 192 of 2020 and Judicial Magistrate Kamrup Tamil.
Well,
Deeply obliged. Deeply obliged.
Office 28 10 5 service data full respect 1 week time granted.
Learned counsel for the petitioner prays for 1 week's time to take fresh steps. Respondent number 2.
One
On the sole respondent. List the matter after 1 week.
Is a plot time from the respondent. Time to find traffic.
Learned counsel appearing for respondent number 2 prays for time to file a affidavit. List the matter again on. When do you want?
After 1.
Not be served. But if the law would find this case, my lord, format and there was a little bit of quarrel case because the client engaged this petition and the IO instructed the informant to appear. So there was a little bit of quarrel, my lord. Thereafter, my lord, this petition, my lord, filed a thereafter, in counter, my lord, filed a FIR. In the FIR, my time of filing the charge sheet, my lord, even the informant was also made an accused. And your lordship would find the last elections, my lord. Then she came for quashing against her. Lordship would find the order as page 53. And this was format. Now this petition and the observation, your lordship could find the observation.
Anyway, we need to have him before us.
Yes, now my the only
So how,
problem.
why insufficient address? How is it? Advocate, where is he residing?
Right, I have found about the. Now, my lord, there is no provision for dusty service. If your lordship permits us a dusty service, then my lord, we can at least serve her. Because even the charge sheet, lordship, the charge sheet, none of the indicated petition. Because in FIR it is petition proof hot water format. Whereas the tender was examined, it didn't happened. But neither in there was a even the prosecution inspector office.
Notice on respondent number 2 is not yet complete, and as per office note, postal notice issued to the respondent number 2 has been received back unserved with postal remarks insufficient address. Petitioner, learned counsel for the petitioner, prays for affecting dusty service on the respondent number 2. Prayer is allowed. Not take dusty service. File benefit in this regard. Again,
Hello.
interim order passed. Continue.
Delegate for bail. Yes,
IA
I
for suspension of sentence.
and bail.
What is the sentence?
10 years. Yes. Under section 4 of Ox-
Anybody appearing for private respondent? Submitted any objection?
The bail application as ground, what is the grounds for bail, and otherwise, Lordship, 10 years, there is very much here. The Lordship directs the for hearing.
There is dispute.
Diverse views.
My lord.
How can we say that you are the only right view?
My lord,
Other side may have a contrary view. He may come with another judgment.
that is, my lord, true, my lord. But coordinate bench of the honorable court.
Is there any law that if the question is only one of law, then the principle of audio alternative partem is not to be adhered?
Yes. But if your lordship permit, I want to submit the judgment, exactly what says in that parameter.
Yes.
Paragraph 65, page 368.
No, we don't want to see this.
My lord.
This is regarding affidavit.
Yes, my lord. This is regarding-
Want to see what is on the respondent before us.
According, this
You
judgment-
can't pass any order without hearing her.
My lord, my lord. Office note dated, my lord, 6/6/25, I think, my lord, service avoided, my long back office. Long,
Why is it awaited? What is the difficulty?
I don't know, my lord, actually,
Your wife.
Yes, hello.
Your wife,
Yes, now she's got married with another person.
you must be knowing,
Hello.
must be knowing where she is staying.
So actually, now she's married to another one. After our separation, Mala, and during the pendency of the
You are supposed to provide the current address.
so actually that is her
That is
father's
your
address.
duty.
Her father's address. Ma'am.
And if she is married,
Party. Daughter, yes, my lord, her father's address. Now subsequently she got married with another. That address.
service report awaited for since September.
My lord. If possible, can it place before the laws in my court whether they will trace the acknowledgement? But that otherwise, my lord, honorable court can engage my guess. Uh,
It is better if you take fresh steps.
I don't have any problem. I can take it.
Yes. As per office note, service on respondent number 2 is not complete. Office note dated 6/9/25. Petitioner to take fresh steps. Can you trace the present address?
Yes, her present address, my lord, her father's address. And if notice will go that address is informed by her parents.
Take your chance. List again on after 4 weeks.
Date if possible.
Hmm?
If possible, any date.
Yes, give a date after 4 weeks.
But in this sentence,
Hmm?
some sort of sentence, I was some sentence. Yes, well, person. Hence, you are granted by the person.
Who were granted bail?
Well, persons were dear man. Events were granted bail. Have submit.
Respondent has been served.
Yes, ma'am. The dear name is
I'm here for lordship.
Yes, what do you say?
Doctor has no objection. I'm here for the doctor, lord. As per number 2, he has no objection.
I can't follow. Doctor?
informant was doctor, ma'am.
Informant was doctor, lord.
There one thing is there, Lord, as it is, maximum period is 10 years.
No, what other, why have others have been granted it is submitted?
Yes, ma'am.
But objection need to be filed, Lord. Yes. Whether it has been filed or not earlier, not aware of it, Lord.
All right. On the prayer of learned additional PP for time to file objection.
Lord,
Is the matter again on?
Weeks after, Lord.
Lord, other cases they have not filed up.
But in
These
10
cases are
years,
not-
10 years,
definitely in other cases, not 10 is also dear man. He was behind the bar from the last 1 year, my lord. After before passing of judgment, he was 1.5 hours, all total 2.5 years in behind the bar, my lord. Kindly, his age is 21 years, man. At the time of judgment, he was 18 years, man.
what should
All
we
right, 1
decide-
week.
what should we decide on?
1 week you can.
Kindly fix the date.
Yes, the date.
And the applicant returned the petitioner was convicted for section 7 They was sentenced to 1 month under section 79, 6 months under section 3 to 4A. Thereafter, my lord, the petitioner filed an appeal that has also thereafter.
This is for previous bail, allowing him to remain on previous bail.
I'm on as well. That means
Third learned counsel, the bit. Additional between appearing for.
There was a conduct that was and then
This is for previous bail,
lordship.
not for suspension. He's already on bail.
Yes, sir.
Miss
6 months.
so who has appeared as amicus in the I number so and so,
number
delay condonation
9/4/2020.
also appointed to represent the government in the I, which has been preferred seeking preferred to allow the applicant to remain on previous bail. On perusal of the court, provided that the prisoner shall be allowed to remain on previous bail. Connection with give the case. Highest tense disposed of it. In the revision, you write in view of order passed in I number so and so is the matter for admission. Yes. Yeah, give the date.
After 7.
All right.
Here I correction of the address name the Costa will be converted. Yes.
What is wrong?
On page 4, my lord will find the correct address name title. Right? Correct.
All right. In this IA, you write this application has been preferred seeking correction of the address and father's name of the respondent number 2. Stated that the address and father's name of the respondent number 2 was inadvertently written as follows. Paragraph. The correct father's name and correct address. The rest. Next page. Accordingly, the post titles and corrected by assistance corrected as above. Necessary changes shall be made to the post title. Of the connected criminal petition.
Lordship, the case diary was called for, but the same hasn't been received yet.
What about respondent number 2? yet served. This note is not there. Respond. So, service of notice upon number get complete. CD received. CD also not received. The matter again on the date.
Right.
Put upon the rest. Like to be served by motive the court wherein the present trial proceeding the party.
10 copy of PCR received has been received. Service on respondent number 2 is awaited. Petitioner is allowed to take justice service, effect justice service and submit affidavit accordingly. The matter again on.
On the next day of proceeding of the trial,
Just give a date.
but mention the trial court, court of JMF Sitaram. The next day of proceeding of the not yet issued by this. Here,
I'm not following you. What is to be mentioned?
I would like to take service fire in
There, in the court. That is up to you.
when next day.
Mention that where you will take it.
Oh, or direct that, then
Justice service means you can effect it wherever you can. Court will not serve it for you.
no, I will take it.
You meet her there and serve. What?
Otherwise, they will not. Because the present address
If
file.
they do not receive it, you submit affidavit accordingly. Sentence, what sentence?
Regarding service upon. Number 2 will present. Rabbit.
You want to say that, want us to say that justice service will be effected in the court.
Trial court.
All right, put it there. Permitted to effect justice service at the trial court on the next day of.
Here,
The next day of CR case number.
Yes. At the JMF.
Yes.
I mean, hearing yes. 7 years conviction standard. I have prepared a small note. Till 10 PWS.
So it is 7 years.
7 years. It is short term.
What, any objection filed?
7 years.
7 years, no written objection. Yes, Lordship, victim is the.
You're in
parents.
jail since when? Since when are you in jail?
Lordship,
This my lord,
just
date of judgment is my
28
lord,
June 2020.
1 year, 8 months, 7.
I will dispose of this.
There was W6, the victim.
Hmm?
W6 is a relevant.
Chamber.